will be permitted to mention one matter. Initially, matter was appearing in the list before my Lord Justice Anidya Rai. The item number 26. After change of determination, not appear. Then
In the stage of
in the
hearing.
stage of motion, under matter to appear for order. There was a direction for order. Matter was appearing under the heading for order. Not appear. Then I serve notice and mention up before my Lord. And on 26th March, my Lord allowed my prayer. Even then, my Lord not appeared. Then I mention on 28th April. On that day also, my Lord allowed. But till today, my Lord, the file is lying. Determination should die that on that way, on that court, my Lord. Yes, man. The determination was there, my Lord. Before that court, my Lord was sitting before.
No, determination was changed from 1st April.
No, my Lord, the land determination, my Lord, the change, my Lord, when I mentioned, my Lord,
be there as it may. Yes.
File is lying before my Lord.
Very good. It was directed to appear in court orders.
Yes, my Lord.
File আমার কাছে পাঠাবে তো দেখে নেবো।
My Lord, there, I have
for orders গুলো রয়েছে। Wait for some time.
Matter is very urgent.
Sir, everybody has urgency.
The possession of the land of the
file আজকে আমার কাছে বিকেল বেলা পাঠাও, নিয়ে এসে দেখে নিচ্ছি। Yes.
My Lord, this is similar circumstances. The matters appearing before Justice Anidya Rai. They have disappeared when the determined change in this court.
Hand over the slip.
Kindly.
Lordship,
for motion matter, just hand over the slip.
Lordship, these 4 matters, Lordship.
Wait for some time. Motion matter, hand over the slips.
Lordship, 17th April, I have mentioned.
Sir, wait for some time.
May be permitted to hand over.
Lordship, 17th April, I have mentioned those matters. Your Lordships allowed.
Under the hearing for motion.
All our motions, Lordship.
Hand over the slip. এগুলো মানতে এসে তো চলে আসা উচিত ছিল কেন? না ওরা ও কথা বললে তো হবে না। কে ডিপার্টমেন্টে চার্জে আছে? হ্যাঁ, বিকেলবেলা আমার সঙ্গে দেখা করতে বলবো after 4:30.
My Lord, I am for appearing from the
motion matter.
Motion matter. New motion.
Hand over the slip. New motion, hand over the slip.
3 hearing matters. Let it be included in the list.
I will serve notice.
But I am saying leave to pay some upgradation. It is appearing in the list of 91.
I understand, sir.
Emergency. That's why I am.
No, sir. Don't embarrass this court.
Because respondent.
Wait. What happened? What happened?
My Lord, next 2019 till 2015 it is there.
I have, yes, up to 2018, 15.
2015 and after that 2023 onwards. Right?
2023 and onwards, motion and hearing and
23
up to 2015. So I don't have it. Yes, sir.
I am paying some upgradation. There is an urgency, but that's why I am paying on last occasion.
The motion matter?
Motion. This is appearing in the list item 91. There's some urgency. That's why I am.
Item number 91 on the monthly list?
Monthly list.
What is the urgency?
Urgency, respondents are trying to encroaching my land without giving any compensation.
What are the respondents?
Land acquisition.
Shankar Chandra Dhara.
Yes, Mr. Dhar, Supratim Dhar, learned senior advocate is appearing for the state. I shall inform.
Wait. ওটা আমার কাছে দিন। মোশন নিবে। Very good. On April 10, 2025, it will appear at the top of the list. But in the event I do not find any urgency,
Lord,
and in the event I find no merit,
yes, my lord.
get
My lord-
yourself ready for getting a huge
My lord,
cost.
my lord has been pleased to direct the matter to appear on
Oh, May. Sorry. If I find no urgency and no merit,
my lord,
get
My lord.
yourself ready for the cost.
my lord. 10th of May,
Yes, if
My
from other side.
my lord, my lord,
এটা একদম আইটেম নাম্বার 1 এ থাকবে।
my lord. Grateful. my lord.
Call the list.
I'm for the statement.
Lord, may I beg to appear for the petitioner?
Possibly Saturday, but
ও এই দেখি দেখি ওর দেখি দেখি দেখি।
6, 7.
আমি তো এপ্রিল থেকে করছিলাম। সরি। Then it will be on May 8.
My lord, my lord.
May 8, 2025 at the top of the list.
Last.
Yes, call the
Item
list.
number 1, my lord, I beg to appear for the petitioners.
Why it is appearing in the under the heading forwarders?
Lord, on the last occasion, your lordship was taken up the hearing of the matter. When, my lord, your lordship has been pleased to extend the interim order up to 15th May.
Exchange of evidences are complete, or you have submitted
I have
report?
not filed any
You have
report.
not filed
It is
any
appearing as
report, no
forwarders
submission.
because বলে দিই তাহলে তুমি তো ছিলে না। Appearing because we took the point of maintainability because it's a notice under 10.1 only. He has the remedy under 10.2, 10.3 because he has not appeared there. He has asked for stay of the notice. He can take up all the points because we have not removed, my lord, and your lordship observed that your lordship will say that till the conclusion of the section 10 proceeding,
Absolutely.
no corrective action
Absolutely.
shall be taken. For that, your lordship kept it.
But may, my lord,
Where is the order under challenge?
no, Lord, may I indicate just?
81
Lord,
and 82.
Lord, may I just indicate?
78 onwards.
Lord, may I just indicate? Lord, Lord, some facts, Lord, may I
I
just-
will indicate. I will allow you to indicate. Show me the letter which is under challenge before this.
Page 81, 12th March.
Page P, no, P7, annexure P7,
Page number, sir.
page number 81. And thereafter 82. Thereafter 82. P7 and P8, 81 and 82.
Yes, sir.
Yes.
Now you may make your submission.
Yes. Lord, the very short background of this writ petition is that why I have challenged the notice. Lord, there is no reason. There is an alternative remedy. Your lordship has seen. I have also, my lord, seen from the West Bengal State Highways Act, 1964. Lord, I have seen that there is an alternative remedy to challenge after the order being passed by the competent authority under section 10.3. Then, my lord, I have a scope of 10.4 to the learned district magistrate. That's right. There is no dispute at all. But here, entire thing is being done, my lord, at the instance of the private respondents. Why I am saying so? Because, your lordship, initially, my lord, 3 writ petitions were filed by the private respondents. My lord, trying to evict me from the Rayoti land. Why I am saying so Rayoti land? I will show you lordship the document here, which I have annexed here. Because behind my place, behind my shops, behind my residence, my lord, there is a hotel constructed by the private respondents. Since there is an egress and ingress problem to enter the car, 4-wheeler car, my lord, they are trying to insist to evict us from our Rayoti lands. Because of that reason, I have come before your lordship and filed this writ petition. I say in this writ petition that, my lord, the authority has no scope to invoke the jurisdiction under the provisions of the West Bengal State Highways Act 1964. Because the land which is governed for this purpose is a Rayoti land. Only one document I will show, thereafter I will go to this. Lord, your lordships kindly have a look of the page. I'm just coming to that page. This land, my lord, cannot be the subject matter of the proceedings. Because of that reason, I have challenged. I have come, my lord. P18. P18. I am just 1 minute time, my lord, your lordship kindly give me. Very well, your lordship kindly have a look of the page 18 first, annexure P1, page 18.
Sir, where is the perversity? That I want to know.
The perversity is that, my lord, government
It is a
cannot-
judicial review.
No question of review.
It is a judicial review.
No question. This is judicial review.
So where is
Under
the
Article
where is the
226,
perversity? I want to know.
Yes, perversity in the sense, Lord, that they cannot initiate the proceedings of the particular land, which is a royalty land, not the government land or acquisition by the
Take this
government.
point before the executive engineer
No,
or the assistant engineer.
that point has already been taken. That point has already been taken. That's why, my lord, 10 to proceedings.
That is why I want to
10
know.
1.
I want to know from you that where is the perversity? That I want to know.
Perversity has that, my
Show
lord.
me the perversity. I will set aside the order.
No, there is no question of order here at this stage.
Very good. Set aside the notice.
Notice. So for the notice is concerned, we have challenged the notice simply on the ground that the private respondents on the earlier occasion filed 3 writ petitions, which that 3 writ petitions were dismissed on that ground. On that ground, I will show to your lordship because they are documents.
So
That's why I am coming.
who are restricting you? So
Kindly have a look at page 18.
time is running out.
Page 18 first.
Yes.
First document, kindly have a look at.
The
P1 page
coordinate
18.
bench has come to a finding that is a royalty land.
Yes, I will show to your lordship.
Show me the relevant.
Kindly come to page 18 first. That is the writ petition. That is the order of the writ petition. Will kindly see. At page 24, the order. This is the 2015 writ petition. Before that, the 2012 also writ petition was filed. At page 24, you also got it. On merits, the writ petition was dismissed. Same thing. Same they have prayed for.
Sir, try to understand my question.
Yes.
You have challenged the legality, validity, and correctness of the notice.
Notice on the
Sir,
two
I
grounds.
want to know where is the perversity.
Look, I have challenged the notice, veracity of the notice only on 2 grounds.
So,
My first ground is that this honorable court on the earlier occasion, all the matters have dismissed the writ petition. This is one aspect. And second, 10-1 has been completed, 10-2 has been completed. I have been directed to evict.
Division bench has directed the authority to comply by initiating a proceeding. Kindly
Not
come
only one,
32 and
only
33.
one more document.
It is misleading, my lord.
Only one
Kindly come to page 32.
up to 1044, you have not shown any perversity.
No, only one document.
So-
Only one more.
No,
document. Apart from the orders, your lordships kindly have a look of the
ডিভিশন বেঞ্চ বলছে অথরিটিকে প্রসিড করতে সেটা দেখাচ্ছে না
Lord, if your lordships kindly have a look of the Lord, your lordships kindly have a look of the
জুডিশিয়াল ইস্যু নিয়ে কি হবে
He will get a chance to contest.
ন্যাচারাল জাস্টিস ভায়োলেট হয় দুটো পয়েন্ট 4 পয়েন্ট
your lordship kindly have a look of the page 76. Only one page. Page 76.
33 ডাইরেকশন দেওয়া আচ্ছা বাইন্ডিং
Page 76 at Lord NSA P4.
Hmm.
Now, this is the reference above. This is to inform him that upon verification, it is found that the plot number so and so. Now, this is a very vital thing. 1778. CS plot number 1778 of Muja so and so, jail number so and so, each are not enlisted in the overlapping register, initial register for nothing, noting acquisition, requisition. The given information is subject to change if any other information. This was issued in the year 2023. And before, after that document, at page 77, this was also issued in the year 2011. That this land was royalty land, this was not the acquisition land. Apart from this land, my lord, they can take any
Ashu,
steps. They
this
can
court-
take any steps.
This court has heard
I'm appealing for the municipality, my lord. Response number 7.
But here, my lord, the
Give me
petitioner
a
being,
second.
my lord,
Who is appearing on behalf of the respondent number 1 to 9?
I'm for 7. I'm for the 7, my lord.
Mr. Banerjee is appearing.
Yes.
State is the respondent number 1 to 5.
1 to 6.
No, 1 to 6.
6.
Then who is for the municipality?
I am appealing for the municipality with my land.
Very good. And who are the private respondents?
9.
Avicii Traders.
Yes.
And who is for the respondent number 8? I will serve notice.
yes, my lord.
Respondent number served.
I have filed, my lord, the affidavit of service.
Silver Peak.
Yes.
Silver Peak. You have sent 7423. Seven, 4, 3.
On 21st of April 2025, my lord.
Not delivered. Address C cannot be located.
Service only.
Be that as it may. Yes, sir.
My lord. My lord, here, my lord, petitioner being the president of the Laha Sporting Club, my lord. My lord has prayed for the allotment of the piece of land, my lord, whereby, my lord, and the original position of ponds and demolishing the unauthorized construction over and above, my lord, has been classified. The land has been classified as, my lord, Lakhe Raj, my lord.
Lakhe?
Lakhe Raj, my lord.
Lakhe Raj.
which means, my lord, rent-free land, my lord, and free from, my lord, revenue and operations, my lord. If your lordship kindly comes to page 36.
Yes.
My lord, this is the definition of the Lakhe Raj, my lord. And more so, my lord, I made a representation, my lord, 2 representation, my lord. One
Lakhe
is,
Raj is a revenue free land.
my lord, and the rent-free land, my lord.
Yes. Then
My lord, and if your lordship kindly comes to, my lord, page 96, my lord. My representation, my lord. My lord, may I read, my lord?
give me a second, sir.
My lord.
Page 96.
My lord.
Yes.
My lord. May I read, my lord?
Yes, kindly
Alright.
please.
To the additional district magistrate, North Chobish Pargana at Barasat. Sir, following facts and figures are furnished in thumbnail for the veracity of the pendency of ULC proceeding of 1976. And the land has been earmarked as Lakhe Raj land. And the filled ponds illegally. 3 ponds has been filled, my lord, illegally. Entire land measuring 44 bigha, 3 katha, 8 chitak, but recorded as 40 bigha, 2 katha, 10 chitak. That is 4 bighas are unrecorded, and out of which 15 bighas are earmarked as Lakheraj / Niskal land in RS Khotia number 182 of Tarapukuria Mauja. As per ULC Act, the entire land has already been come under the purview of ULC Act, and in pursuant to the ULC Act 1976, ULC proceeding was started in the year 1976, and it continued up to the stage of submitting return under section 66(1) of the ULC Act, which was recorded in the register of under section 6(1) of ULC Act as serial number 3865, dated 9th October 1976. On my request, several letters were issued and sent to ULC Department, Barakpur, from the Department of Urban Development and Municipal Affairs, Salt Lake, for compliance to make the ULC proceeding regularize. But ULC officer and SDO Barakpur ignored all the letters received from Urban Development and Municipal Affairs, Salt Lake, in respect of Lahabagan, Panihati, and they did not give any reply to the Urban Development and Municipal Affairs urban land ceiling since 7th August 2020 to till date, in spite of several reminders were issued by UDMA urban land ceiling, Salt Lake, and sent to ULC Department, Barakpur. It is simply for the vested interest of the ULC officer, ULC department, and other concerned department, which is not desirable to us and needs for taking action against him, and the matter should be placed before the SDO Barakpur for compliance immediately till the processes of vesting have been completed. Keeping aside the ULC proceeding of 1976, another ULC proceeding was started in the year 2018, which is unmoved without any correspondence since 7th August 2020 to till today. In spite of several reminders were sent to the ULC department and SGO Barakpur from the Urban Development and Municipal Affairs at Nagarayan, Salt Lake, and needs your proactive intervention to conclude the ULC proceeding of 1976 and 2018. Malat, I am not reading, Malat, I am reading the important part, Malat. If your lordship kindly comes to Malat, page 98, Malat. No action has been taken by the director, North Chobish Porgana at Barasat, Malat, paragraph 9, Malat, and chairman Panihati municipality against the fulfilling of 3 ponds and fisheries department at Barasat reported to the concerned authority of Panihati municipality by letter in writing in DAG number 513/506/996 in Tadapukuria Mouja, and another in DAG number 642/914 of Shodhpur Mouja. In spite of your direction and knowingly the veracity of the filling of 3 ponds as per record of the BLLR and LRO Barakpur office. Further, I like to add that we went to the Honorable Chief Minister's house at Kalighat, Kolkata on 5th July 2016 for her great assistance against the big scam involved at the said place at Lahabagan, Panihati, which has been evolved for being perpetrated by promoter and their men and agent with the assistance of government concerned authorities. On hearing of our complaint on that day, the Honorable Chief Minister West Bengal passed a restraint order of illegal construction at Lahabagan to protect the football playing children of Laha Sporting Club and their playground at Lahabagan. Also, accordingly, illegal activities were stopped at that moment. At this stage, please take an action against the private wrongdoers and dishonest government concerned authorities who are involved into this unlawful activities at Lahabagan, Panihati in the eye of law, and allot an adequate land in favor of club by vesting the land as per provision of ULC Act and concluding the ULC proceeding wholly, if not concluded the same, and relying on the veracity of the said land under ULC proceeding and that part of the said land measuring 15 bighas.
So what is your locus standi?
Malat, kindly, Malat. Malat, I am there, Malat, since the year 1985, Malat, and continuing with the Malat, the children are playing footballs and we are giving training to them, Malat, and it is 44 bigha is with us, Malat, since at that point of time, Malat, from the original owner, Malat.
By way of?
By way of getting the possession, Malat, from the original owner, Malat, because they have filed a suit, but they failed, Malat. From that time, Malat, we are enjoying the property, Malat.
So and you intend to protect the property?
Malat,
what is your status in the property?
Malat, I am only because, Malat, otherwise, Malat, we will not be able to, Malat, give assistance to children,
Malat. Why?
Malat,
for land will...
I am only here, Malat. Kindly, if the authority could consider my, Malat, representation, Malat, I am only upon this, Malat. Okay. Nothing less, Malat. And 3 illegal construction has already been done, Malat. 3 ponds have been filled, Malat. I am only, my lord, harping that may my representation be at least considered.
That cannot be. My lord, kindly come to his prayer.
As the property is in the nature of, my lord, Lakhe Raj, my
Mr.
lord.
Banerjee,
No.
what interest he has got?
Nothing.
But
But-
application for mutation of their name regarding
Well,
that
may I-
mutation,
well,
are
may I-
pending under
Guruji,
in their status. They are claiming that they need mutation of the property. That is pending. And they are
Have they been fortified with any legal document or instrument?
They are claiming that we should complete a ULC proceeding and get it vested and allot to them.
That has been done.
So if he is
That has been
interested
done.
for any public purpose,
But kindly
let him
come.
file a public interest
Yes,
litigation,
but
Mr.
kindly
Banerjee.
come to page.
But one more point. One is that if there are club public interest. Secondly, the representation they are asking for consideration that says after completing ULC proceeding, allot the land to us. Kindly come to the representation for 28.
Page 84.
So if they
84.
are asking for allotment, below that is again below the settlement of land under land reform.
That is their prayer in the writ petition.
Consideration of the representation.
But kindly see the prayer. Kindly see page 31.
I will allow you to make your submission.
Right.
Now ask some question to Mr. Banerjee.
One below. First is the demolition of construction. And these who call the investigation in terms of the representation of the petitioner dated 25/11/28. The representation 25/11 and 28/11. 2020. Representation is for settlement of the land in their allotment of the land.
No, have they made any prayer to that effect in the
Yes, my lord.
representation?
Yes, my lord. Prayer A and prayer B, my lord. Page, my lord, 21.
Illegal construction there and
Nothing.
stop running and reinstate those
Prayer.
pukus mentioned and which is already appropriate authority for prayer. And so
Last but one page below.
Pukur was based on record.
Bottom.
Kindly pass order to submit report by the said agency. Yes, sir. Now you make your submission.
My lord, kindly come.
You are for the municipality.
Yes, I am for the municipality. Kindly
Ah.
come page 18, my lord.
Page
18. 1/8.
1/8.
Yes, 1/8.
Yes.
May I read my can see? That being agreed by, dissatisfied with the inaction and or silence on the part of the respondent authorities against your petitioners, your lordship's petitioners, representation dated Sansas and in connection with illegal mutation order passed in Miss case number 233/22, 234/22, ADM LR District North Parganas, Barashat, arising out of Miss Appeal number Sansas. So, this is a case of mutation that has been allowed not in favor of him. He's challenged this. It is under Land Reforms Act. Mutation under section 24. If you should next come to page 84.
Illegal mutation order passed in Miss Appeal number such and
Yes.
such.
He challenged this.
Who are the appellants?
But kindly see, they are the appellants.
Petitioners represented in connection with.
Yes.
So mutation has not been effected in their favor.
No, not. I come to page 84. What has been passed, taking into consideration the ULC also. Page 84. Page 84. Both the appeals cases are taken up together today for analogous hearing. Both the appellants and respondents filed haziras through their learned advocates and remain present on call. Needless notice are duly served and service return found Sansas. Heard the both parties and examined the documents in details. Prima facie, it appears that the mutation cases being number Sansas were executed in favor of one Silver Peak, that is one number 8 hearing. Silver Peak Solution LLP against the land schedule LR plot number Sansa Arapukuria matter number sansas, LR Khoti sansas, which was recorded in favor of Avicii Traders Private Limited to LR Khotian number sansas in favor of Silver Cup Solution LLP by registered deed number 10625 dated 19 to 2019, registered at DSR 1 North Pagunas. Further, it appears that Parvati Charun Laha was the recorded tenant of RS record, and subsequently the LR finally published ROR was also framed in favor of Parvati Charun Laha, son of Bhavani, in LR Khatian number 597 of Mauja Tarapukuria, jail number 12. One of the legal heirs of Parvati Charun Laha, Tripti Laha, sold out a portion of land to OVC Traders Limited, and the same was mutated in LRROR number 1497 by mutation case number Sansas. Again, it appears that a further transfer was performed by deed number 10625 dated 19 to 2019 under DSR 1 Notre Pagunas to Silver Peak Solution LLP, and thus both the mutation cases were executed by the prescribed authority under section 50 of the West Bengal Land Act 1955. Further, it appears that the Laha Sporting Club, as per their deposition, was enjoying the portion of the land in question for some social welfare activity as a playground, as per verbal consent of the CS and RS owners, late Bhavani Charun Laha and late Parvati Charun Laha, son of Bhavani Charun Laha, but neither any legal instrument is available with them, nor they are reflected in the land records as CS record to LR record. Laha Sporting Club submitted that the land in question connected to mutation cases number Sansas are connected to a pending vesting under the provision of the Urban Land Sealing and Regulation Act 1976, but they were unable to produce any conclusive proof that any vesting proceeding were initiated under the ULC AR Act 1976. Next page, madam. As per the settled norms, the prescribed authority under section 50 of the West Bengal Land Act 1955 makes usual reference to ULC and LA, etc. And as per the L and LR Department Government Geo number Sansas, dated Sansas, if no reply is received within 30 days, then it will be presumed that authority department reluctant has no objection in granting mutation. No such reply was also proved by the
So
ULC.
this order has been passed under section 54 of the
Yes.
West Bengal Land.
Yes.
So it is an appeal. So the
And moreover, yes, madam.
it's a specified act.
Yes,
So
especially
it
that.
comes under section 6.
Yes.
That is the representation.
But-
That land has to be allotted. It goes to the Land Reforms Act 1. Secondly, mutation cases are pending.
It is a specific act within the meaning of section
Yes.
4.
Yes, madam. But
And the other, there are two prayers. One is regarding allotment. That is under specified act. Other is that the ULC proceeding should be completed. That will not, he has no locus.
lowest address.
There are two parts of his prayer.
But may
One is ULC proceeding, the other is Land Reforms Act. Land Reforms Act is not to be relegated to the tribunal.
LRTT.
So the order which has been passed under section 454 is to be challenged before the tribunal.
Yes. Tribunal. Now, may I hand over the judgment of this court?
Not required.
Where my learned friends are party?
Asuna.
May I hand over this?
Right.
Learned, this tribunal court,
He has no locus.
locus.
There is that ULC completed.
That
Yes,
is
yes.
That he has no locus.
locus.
Yes.
He cannot comment.
And mother,
Listen to my order, sir.
club has no right and interest over the property.
Very good. I pass the order.
My lord.
Deeply obliged, my lord.
On 26th of December 2024, our coordinate bench passed an order, my lord, directing the authority to file a report in the form of affidavit. Since they couldn't file the same in time, your lordship was pleased to extend the time by order dated 7th of April 2025. Now, last, my lord, Thursday, they have handed over a copy of the same said report to us, my lord.
But may I file the report?
You have served advance copies.
Yes, Thursday, my lord, they have. Thursday, my lord.
So let us proceed.
Or, my lord, if your lordships kindly permits me to come with an exception, because it's about my dias non period, but a sand mining agreement for 5
The
years.
affidavit, the report in the form of affidavit.
Note 7, I appear for the petitioner. My lord, the
Give me a second. Mr. Dey is appearing. Oh, very good.
my lord,
Give me a second, sir. Give me a second, sir. Is there any private respondent, sir?
no. Only the Panchayat authority, that too is not a private respondent.
Very good. So who is for the Panchayat then?
Yes, they should appear.
Respondent number 7. What is your affidavit of service?
Of service, my lord. That is the affidavit of service. I have served them.
Respondent number in writing is a notice along with the server copy of the respondent 27 by ASO by speed post. দেখি কি আছে দাও তো বাবাটা
Not the affidavit of service is there.
Service has been effected, sir.
Yes, my lord.
সভাপতি and অঞ্চল প্রধান. Mr. Dey, have you got any instruction who appears on behalf of the Panchayat? There is no necessity. No, I'm doing it is his petition.
Yes.
Yes, what is your prayer?
My lord, the prayer is, my lord.
I am stating the facts. Only
I'm fact
এক minute, fact.
Yes, yes.
Please see the first page of his application. That is West Bengal Land Reforms Act 1955. That will debar him
That
to
may
file
be,
this
my lord,
application.
that cannot be the issue for,
That
my lord, the issue fact of the case, my lord, I am submitting what has happened. Your lordship kindly have a look. take trouble for one moment, please page 20, my lord.
Page number
Page number 20,
20.
20 only. That is, my lord, that has been obtained on 5th of March 2025, online record of right, wherefrom it appears, my lord, the land in question recorded in favor of, my lord, the Lord Maheshwar Mahadeva, and that is the Devottar property. And there is, my lord, some other other properties, my lord, separate dag numbers, which are, my lord, the water body. My lord, the filling up the water body, they are constructing a building.
Who are constructing, sir?
The Panchayat authority and the block development officer, because of Anganwadi project is being conducted. That's the difficulty. Well, government authority is doing this.
Say, place the letter. Place the letter. Place the letter.
My lord.
Letter of complaint or the representation.
That is page 21 onwards, my lord.
Page number 30 is the last one.
Page number 30 is the last one.
Kindly place, sir.
Page 30.
আমাদের বিনীত নিবেদন এই যে আমরা রামনগর থানার অধীন রামনগর 1 নম্বর ব্লকের অন্তর্গত হলদিয়া সোয়াংশ আমাদের গ্রামের সরকার বাহাদুর অঙ্গনওয়াড়ি কেন্দ্রে স্থায়ী গৃহ নির্মাণের জন্য অর্থ বরাদ্দ করিয়াছে। যে স্থান নির্ধারণ করিয়াছে সেই জায়গা প্রাচীন মহাদেবের মন্দিরের ধর্মীয় স্থান হইতেছে। উক্ত স্থানে মহাদেবের বিভিন্ন প্রকার ধর্মীয় অনুষ্ঠান হয়। মহাদেবের ভূমি 1485 দাগে ডোবা রেকর্ডভুক্ত, তাহার উপর ভিত খনন হইয়াছে। উক্ত ডোবায় মহাদেবের ঘটোত্তোলন হয়। এমত অবস্থায় নিম্নে উল্লিখিত তপশিল সম্পত্তি সরকার বাহাদুরের রহিয়াছে। সেই সব জায়গায় না করিয়া দেবতার নামিত রেকর্ডভুক্ত জায়গার উপর করিবার জন্য অসুবিধা হইতেছে। উল্লেখ থাকে গত 5/6/2024 তারিখে বিএল অ্যান্ড এলআরও রামনগর 1 আধিকারিককে এবং আইসিডিএস রামনগর 1 আধিকারিককে এই মর্মে আবেদন জানানো হইয়াছে। উল্লিখিত সোয়াংশ দাগগুলিতে যাহাতে অঙ্গনওয়াড়ির গৃহ নির্মাণ করা না হয়, সেই হেতু সরেজমিনে তদন্তপূর্বক সরকারি জায়গায় যাহাতে অঙ্গনওয়াড়ি গৃহ নির্মাণ হয় তার জন্য আবেদন জানাই। কোনো প্রকার তদন্ত না হওয়ার জন্য পুনরায় 13/11/2024 তারিখে আইসিডিএস রামনগর 1 and বিএল and এলআরও রামনগর 1 আধিকারিক মহোদয়গণকে এ ব্যাপারে আবেদন করা হইয়াছে। কোনো প্রকার তদন্ত না হওয়ায় পুনরায় 12 ফেব্রুয়ারি 2025 তারিখে আইসিডিএস রামনগর 1 বিএল and এলআরও রামনগর 1 আধিকারিক মহোদয়গণকে এ ব্যাপারে তদন্তের আবেদন জানাই। বর্তমান আবেদনে 2024 সালের জুন মাসে, 2024 সালের নভেম্বর মাসে হয়। ইংরেজি 12/2/2025 তারিখের আবেদনপত্রে রিসিট কপি যুক্ত করা হইল। অতএব মহাশয় আমাদের প্রার্থনা মঞ্জুর করিয়া সরেজমিনে তদন্তপূর্বক সুব্যবস্থার আজ্ঞা প্রদান করিলে বাধিত ও চিরকৃতজ্ঞ।
So, Mr. Roy, let BLRO make an inquiry and let SDO makes an pass a reason order after hearing both the sides.
One indulgence.
Until then, there shall be no construction.
Grateful to your lordship, my lord.
The affidavit of service as filed today on behalf
May I please your lordship? I am appealing for the petition in this matter. My lord, I have served affidavit of service there. My lord, kindly
Give me
page
a
number
submission.
22. Kindly see page number 22. The petitioner before my lord.
Give me a second, sir.
My lord,
Is there any private respondent?
no. But this is related to the compensation to the landlord petitioner. That is the representative.
You are for the railway authority, sir.
I've served affidavit
Who is
of
for the railway authority?
We
You are for the railway authority. Yes, what is your prayer?
my lord. That is prayer is, my lord, at page number 10.
For 1 to 3.
Page
Have
number
you
10.
make any representation?
Yes, that is at page number 22. That is kept in abeyance, not considered as yet, nothing, no response as yet, my lord.
So let them pass a reasoned order.
Yes, yes, madam.
Stop, Ashwin. The affidavit of services.
See, I have received one instruction, my lord, that land was acquired in the year of 2010. And my lord, that was vested. Thereafter, my lord, the compensation has been paid according to the order of the competent authority to the concerned person. He has received the compensation amount in the year of 2010. And my lord, according to the Railway Act, Chapter 4A, there is a provision. My lord, if there is any objection, they have to raise before the competent authority. My lord, after 15 years, my lord, kindly see what is my instruction. And my lord,
Other questions I have some of the questions
that land was not acquired. And my lord, not only that, my lord, for a moment, kindly see the prayer A.
consider as to whether acquired or not. That is
Kindly see
that
the
is
prayer A, my lord.
kept in
Yes,
abeyance.
give me a second, sir.
Prayer A.
Give me a second. Let me go through their representation.
Madam.
Yes, what is your instruction?
My lord, my instruction, kindly see from at the bottom, paragraph 1.
Yes.
My lord, the writ petitioner claimed being a joint owner. My lord, apart from that, my lord, one submission that he has also claimed for the employment to the railway. My lord,
Yes,
regarding
yes.
that part, that cannot be adjudicated by this honorable court. They have to prefer any
That is in the
application.
representation.
Bolte din na. They have to preferred application before the learned tribunal, my lord. And regarding that compensation part, that can be adjudicated.
Yes.
My lord, that cannot be adjudicated at this point of time, my lord, because that portion of the land which was acquired by the railway, that compensation amount already paid in the year of 2010.
Please place the relevant portion, sir.
My lord, kindly see
May I
paragraph
have a
6.
copy of that report?
You have not sub copy?
No.
Sabhi mein copy?
Yes, yes. I have given the entire documents, my lord. My lord,
Yes.
kindly see
Place
the
your report.
next page 6, my lord. The scenes on
No. Place one by one. So you're in a hurry.
No.
Kindly place, sir.
Paragraph 1, my lord.
Yes.
That writ petitioner claimed to be a joint owner of the said land of 3 decimal according to the right of inheritance after demise of his father late Bhudev Chandra Bhuiya, son of late Bonkim Chandra Bhuiya by virtue of revenue record of rights dated 2/12/2012. The out of 2.14 acre, 214 decimal of the said land, 41.90 decimal was notified for acquisition in connection with the construction and execution of the Deshopran Nondigram 17 km special railway project under section 20A of the Railway Amendment Act 2008 by virtue of Gazette notification bearing number such and such. The Railway Amendment Act such and such is repealed as the Railway Act 1989 Chapter 4A. Herein such and such, the aforesaid 21A Gazette notification was published in Times of India on 26/2010. The parcel of the land measuring 41.90 decimal under the said 20A Gazette notification was subsequently declared vested in favor of the Southeastern Railway Central Government for Desopran's Nondigram 70-kilometer project under Section 20E1 of the said Act, vide notification such and such dated 7/9/2010. The same was published in Times of India on 23rd September 2010. The copies of the related pages of Gazette notification under Section 20A1 of the said Act, vide dated 19 May 2010, and Gazette notification under Section 20E of the said Act, vide number such and such dated 7/9/2010 for the purpose of the instant case are enclosed herein marked Annexure E. That after field verification, it was concluded by the competent authority for land acquisition, Desopran Nondigram New BG Line Special Railway Project, that the entire 41.9 decimal in respect of the said land was acquired from the land share apportionment of the late Ananto Kumar Maiti, who was one of the recorded owner of the said land of 64 decimal as per prevalent revenue record of rights dated 21/12/2010. Consequently, candidature of the Sukumar Maiti, son of late Ananto Kumar Maiti, was forwarded to the senior DPO KGP on 1/3/2012 for job assistance under land loser recruitment category. A copy of revenue records such and such dated 21/12/2010 issued in the name of late Ananto Kumar Maiti for the purpose that is also annexure. 6. Since Ananto Kumar Maiti was demised at the material time of land acquisition, compensation was paid to his successor, Sri Monoranjan Maiti, to whom the power of attorney was executed by the other successor of late Ananto Kumar Maiti. 2,65,546 was paid to Sri Monoranjan Maiti, son of late Ananto Kumar Maiti, towards 80% compensation by check number 745579 dated 31st March 2012. Since the land share of the writ petitioner in respect of the purported land was not acquired for the railway purpose, writ petitioner cannot be considered as land loser. As such,
So,
my lord, kindly see that I have.
how do you claim that your land has been acquired?
Page number 15,
Page number
51, 5 million. Middle, can you got it? I am the recorded owner, Riot. My middle left hand side, my lord, 799 plot number.
Yes.
Can you
My
got
lord,
it?
kindly consider my report. There is a total land of that plot is, my lord,
Page number 15.
214 decimal.
consisting of which plots?
I am
My lord,
of 799,
799.
799. That is left hand side, middle of the.
Okay, give me a second. Where from we'll get the plot numbers in your
left
notification?
hand side, middle.
My lord, at the left hand
Page
side
number
top, my lord.
15.
799.
My lord, the entire plot of 799 was not acquired. Entire plot, my lord, quantum of land 214. My lord, according to my report. And out of that, my lord, railway acquired for their special project purpose, my lord, only 41.90. And that portion, my lord, that the late Monoranjan Maiti, late, my lord, the Ananto Kumar Maiti, and his son received the, my lord, the compensation amount, Monoranjan Maiti.
Let me come back.
And my lord, particularly on this point, my lord, your
Let me come back.
My representative should be considered. If not, that should be written order be passed by the competent authority.
After 15 years,
And 15 years, sir.
husband, put our husband. And
My
that
lordship.
particularly on this point, very recently, your lordship's own judgment is there.
My lord, kindly record my submission Lord, that I am the recorded riot, and in the notification, the land is there out out of 41
There is a
decimal.
specific time, my lord, for raising, my lord, objection, my lord. My lord, that is
Judgment 42,000 দেখে নিন। রিপোর্টে হয়েছে না ডব্লিউপি এটা বল
paragraph,
ডব্লিউপি এটা 24696 12 বলরাম মাইতি না 16/1/25
Here there was a dispute with regard to the disbursement of the proportionate share. But here, according to you, the railway authority, the portion of the land which has been acquired that does not belong to him. That is your case.
that is.
my reply is that my lord
And my lord, whatever railway has done, my lord, that is in compliance of the order of the
The
competent
affidavit of
authority.
service has filed
My
today.
lord, that
My
is
lord,
respondent
may I-
number 4, my lord.
The affidavit
Special
of,
land
the
acquisition
affidavit of
officer.
service has filed
My
today
lord,
on
may I be
behalf of the
permitted
writ
to
petition is taken on
give
record.
reply to his opposition, my lord. My lord, kindly see, my lord, that is their report, paragraph 5, page number 2. My lord, that is on the entire share, the entire land has been of the plot has been acquired, and that is Ananda Kumar Maiti. I am not the legal heir of Ananda Kumar Maiti.
Definitely, my lord.
I am a Bhuya,
But this
and
is
that
he
is
was
there
caught
below
late.
in the notification. My lord, kindly see.
Learned advocate appearing on behalf of the
Page
My
number
lord, one
21.
submission may be recorded regarding that service. My lord, this court has no jurisdiction. That is, my lord,
We have not acquired this land. Why should I apply this?
Acquire notification, my name is there, my lord. That is page number 21. I have placed
That I have considered.
repeatedly, my lord.
Next. Who is for the writ petitioner? None appears on behalf of the parties. On the last occasion, that is on 16/4/2025, the writ petitioners are not represented.
Pursuant to your lordship direction, I have served upon the 5 respondents.
Who is for the petitioner?
I am for
You are for the state. You
I have the private respondent.
come this side. এটা আবার কি এখানে রয়ে গেল?
Today just now received this brief, my lord. Can I adjourn for this day, my lord? Take instruction, my lord, what happened in the title suit, my lord.
any short, my lord, may very short matter, my lord.
Title suit is pending between the parties.
Yes, my lord. My lord, one plot of land has been acquired. There is alimony in recording between the petitioner and the private respondent. One title suit for declaration is pending. During pendency of the title suit, the payment is going on. That's why I have made objection as a representation before the collector, my lord. That has been not been considered.
Collector.
My lord, title suit is pending for declaration. Kindly, I have annexed the
Call for the parties. Petition.
On what account the compensations are going to be disbursed?
my lord, for the land has been acquired.
Mr. Bandyopadhyay,
The National Highway.
what is the matter?
My lord, there, my lord, statement is this, my lord, the land has been acquired for the purpose of construction of National Highway Authority, by the National Highway Authority.
এই ন্যাশনাল হাইওয়েজ একটা দেখি ভাই
But National Highway Authority is not made party to
এখানে
this
ছিল তো
decision, my lord. It's a Kharagpur, Bardhaman,
So
more.
National Highway Authority has made been party.
No,
No.
So made him party.
My lord, payment is being made by the collector. I have made objection before the special land acquisition officer.
Huh?
My lord, payment,
এইটা
so far payment is concerned, but dispute regarding payment.
But there are, my lord, there is a civil dispute
There-
between the parties
Yes,
regarding
the
the
civ-
land in question.
Yes, my lord, civil
And
suit
that
is pending.
No, if there is a dispute with regard to the apportionment,
No,
Yes,
no,
yes,
no,
ma'am.
no.
then it has to be referred under section 3H capital 4.
Yes.
But why the National Highway Authority is required to be made party?
No, my lord, dispute regarding the share of the land, man. They,
সেটাই তো দর্শক বলছে apportionment
পার্টি
বলছে।
করতে বলছে ওকে
we are saying, man, we are the owner of the whole land. They are saying the proportionate.
So there is a dispute with regard to the apportionment.
Yes, that's why my civil suit is pending
Huh?
for declaration.
Huh?
But during pendency of the civil suit, payment is going on. Upon the that is the objection and representation made by the special collector, special labor matter.
এই মাসই ডেট আছে নেক্সট ডেট
No, whether any order has been passed.
No,
So
suit is
make National Highway Authority party.
Your lordship may direct the lay collector to consider
Yes,
his representation, my lord.
this is my prayer, my lord.
His prayer is unless the title suit is, my lord, the disposed of, till
Yes.
disposal of the title suit, no payment shall be
Mr.
made.
Bandyopadhyay, this
Yes,
is regarding disbursement of compensation on account of acquisition of land for the construction of National Highway.
Lord.
Because the National Highway Authority is the requiring body.
My lord.
And the state is your client, the state is the acquiring body, and they are the appropriate authority for.
Yes.
So National Highways Act 1956 says that section 3A that when several persons claim to be interested in the amount deposited under section Subsequent, the competent authority shall determine the person whom its opinion are entitled to receive the amount payable to each of them. Even dispute arises to the apportionment of the account or any part thereof, same shall be decided referred to the dispute the decision of the principal civil court of original jurisdiction.
Payment has already disbursed to the collector. National Highway already the collector
no.
is making payment.
Made national highway authority party. Stop লিখো আসুন. After hearing the learned advocate, the affidavit of service as filed today is taken on record. Would allow me the server copy of this order করে দেবে তো? Survey notice. You send notice to the National Highway Authority. Along with a copy of the instant need petition, along with a server copy of this order.
Upon Mrs. Roy.
বলেছি? Oh, very good.
Upon Mrs. Roy. That will
Directly to the authority as well as to MS Roy.
yes.
2 copies, 2 sets.
Authority as also one. Orderটা দেখে নিও না।
Your Lordship, Mr. Arjun Shamanto is appearing for the petitioner. He's on his legs in another court.
Not today.
Moreover, Your Lordship, moreover, in the previous date, you had directed us to serve a copy upon the advocate for the state and the respondent number 9. But since the order was uploaded on a much later date, the same could not be served. Kindly keep it after a week so that we can serve
On behalf of the read
I'm for the petitioner. My lord, the petitioner is
For the
praying
my lord.
for. My lord, the petitioner is praying for the delayed compensation.
Who is for the petitioner?
My lord, I am for the
You are for the state.
I am a state, my lord. I am raising the maintainability point of this writ petition.
My lord, on the last
Any private respondents are there?
no, my lord, on
Yes.
the last occasion, state sought for time to file a report on the form of
Report is
affidavit.
ready. Report is ready. Only, my lord, the maintainability point I want to raise, my lord, because this writ petition is barred
You
by
have
res
a copy of the report.
Put pecho.
Then file the report. Take down. National Highway Authority is a party, no?
Yes, my lord. My lord, respondent number
What do you
2.
want?
My lord, I am praying for the interest over the delayed compensation. My lord,
No.
compensation has been
May I
paid.
proceed?
Yes, my lord.
Give me a second then. Bush. Yes, madam.
My lord, the petitioner was a landlorder. Land was acquired. Thereafter, the compensation, it was informed the petitioner that she is entitled to get the compensation. My lord, kindly come to page number 22. Page number 19.
19.
19. And this was a notice whereby she was informed that she is entitled to get the compensation.
Place the notice. Place the notice.
Yes, my lord. The notice.
Dipali Maji is the lead petitioner.
Yes, my lord.
Yes. Place the letter, ma'am.
My lord, notice is hereby given that in the above case in which you have been treated as a person interested, an award was made by me on 18th February 2019 under Section 3G of National Highway Act 1956. The same payable to you is rupees 19,77,361. The payment will be made to your account, bank account through PFMS or ECS on the on and
from
from
27 to 99.
February 2019.
Very good.
Thereafter, this interest was not disbursed.
Thereafter,
This compensation was
amount was not disbursed.
No, my lord.
Achha.
Thereafter, the petitioner filed a writ petition.
Yes.
That was the WPA number 2005 of 21.
Page number, madam?
Well, this petition was not annexed, my lord.
I have annexed in
beg
my
apology.
report.
Achha.
22.
You have filed WPA number?
2005 of 2021.
Give me a second.
Let the orders are
Filed WPA
2005
of
2021.
Page 22 is the order.
Page 22
is the order.
My lord.
Only order copy has been annexed, but the writ petition copy has not.
No, that I want to see. What is the order?
My lord, page number 22 is the order.
Oh,
My lord,
that I intend to see. Yes.
My
What
lord,
is the order?
Fourth paragraph, my lord. The operating portion.
Is directing the special land agato
Respondent
take
number
immediate
8
steps
herein
for
to take
disbursement of-
immediate steps for disbursement of the compensation amount of the petitioner in terms of award within a period of 16 weeks from the date of communication of this order.
Yes, madam. Then
Thereafter, my lord, kindly come to page number 24. On 28th June 2021, the compensation was disbursed to my bank account.
28 June.
Yes, my lord. 1, 2, 3.
But it was supposed to be credited.
Disbursed on 27th February 2019. Yes, my lord.
Instead of 18th February 2019,
yes,
it has been disbursed on 28/6/2021.
Yes, my lord. Now, my lord, I am praying for the interest over this delayed payment. My lord, there were several landowners, my lord. Out of them, one of our relative, my lord, that is Rajesh Dotto. Now, my lord, Rajesh Dotto got compensation as well as interest. I am praying for same footing with that Rajesh Dotto.
You are seeking parity.
Yes, my lord.
Where is that order?
My lord. My lord, Rajesh. My lord.
Well, that went up to the Supreme Court. There is no provision, although we have not preferred appeal, therefore, my lord, it is my lord applicable. But there is no provision of my lord to delayed payment of interest.
My lord.
Rajesh Dotto is not applicable, my lord. That is, my lord, another my lord.
My lord, kindly please the fact.
No, let us submit, I will allow it.
There is no provision, my lord.
Very good.
I face the content before the my lord justice originality.
My lord.
Mr. Bandyopadhyay, take your seat, please.
My lord, kindly come to page number 20 and 21. This was the writ petition. This was the order of this honorable court in the writ petition filed by Rajesh Dotto. WPA number 8628 of 2020. My lord, the operating portion is in page number 21. Considering the facts of the case as mentioned above, the respondent number 8, the Special Land Acquisition Officer, Paschim Medinipur, is directed to forthwith pay the amount of compensation of rupees 1 lakh for the these rupees to the petitioner through the to the petitioner's account, particulars whereof are mentioned in the documents disclosed as annexure P4 to the writ petition. Such payment shall be made by the respondent number 8 positively within January 15, 2021. This was Rajesh's order. Thereafter, my lord, this was kept pending. This writ petition was kept pending. List the application under the same heading on January 16, 2021. Only the compensation was directed to be paid, and thereafter this was kept pending. Now, my lord, kindly come to page number 26. This is the next order of Rajesh's case. Page number 26, my lord. My lord, I am placing. The grievance of the petitioner as recorded in the earlier order dated December 16, 2020 was non-payment of compensation receivable by him for acquisition of his land under the provisions of the National Highways Act 1956. By the order dated December 16, 2020, the respondent number 8, being the Special Land Acquisition Officer, Paschim Medinipur, was directed to pay the amount of compensation such and such to the petitioner by January 15, 2021. I am told that the payment of such amount has been made on January 5, 2021. The only issue that survives is one of the payment of interest for delayed payment of compensation. I find from annexure P3 to the writ petition that the respondent number 8 issued an undated notice to the petitioner intimating that he had made an award in favor of petitioner on 18th February 2019 under section 3G of National Highways Act 1956.
Petitioner has been deprived of his lawful dues for a considerable period of time, for which he is entitled to be compensated by of interest. That was the consideration.
Yes, my lord. Kindly come to last paragraph. Considering the facts and circumstances of the petitioner. Yes, my lord. 10%. Thereafter, my lord, an appeal was preferred before the division bench. My lord, kindly come to page number 28. 28 onwards is the order of division bench of this honorable.
It has been interfered with.
My lord, the state filed
It was dismissed.
Yes, my lord. Appeal was dismissed. Thereafter, my lord, they preferred another application before the Honorable Supreme Court, and that is, my lord, page number 34.
Very good.
This is the order. We are not inclined to interfere.
So you are
with the-
seeking parity.
Yes, my lord.
Very good.
Thereafter, my lord, contempt petition has been
Be that as it may, you are seeking parity
payment
with
has
that.
been made. I have made another representation reminder letter, and at the time at first, my lord, we were stated that we were told that if Rajesh got the compensation, Rajesh gets compensation, then you will be entitled.
In writing?
No, my lord, that was in oral. But my lord, I have made a reminder letter to them stating all the facts. My lord, that is in page number 36.
Very good. Any other
My
point?
lord, I
Madam?
am seeking parity.
Yes, sir.
Kindly see my report.
How do you justify your delay?
I'm showing, my lord. Kindly see, my lord, page 10 of my report.
Yes.
This is the writ petition earlier filed by the writ petitioner being WPA 2005 of 2021. Now, my lord, kindly comes to page 24. What was our prayer? Our prayer A. Mandamus commanding the respondent authorities special land acquisition of Paschim Medinipur to disburse the awarded amount as determined, communicated to the petitioner in Annexure 3 along with statutory interest till the date of actual final payment. So twofold prayers were there for awarding the compensation as well as the interest. But the Honorable Court has only granted the award portion, my lord. The interest has not been given. Your Lordship has already gone through page 22 of the writ petition.
Not decided.
Page 22, if your Lordship kindly have a look, page 22 of the writ petition. This is the order in this writ petition. Here, my lord, the direction was given only to pay the compensation. So far as the interest is concerned, my lord, no order has been passed. Although it was her prayer earlier in the writ petition. So, my lord, it is barred by res judicata in terms of explanation 5 of section 11 of CPC. And may I place it, my lord, explanation 5? Any relief claimed in the plaint which is not expressly granted by the decree shall, for the purpose of this section, be deemed to have been refused. So, when the order was passed, my lord, on 8th of March 2021, no interest part has been directed. So, the order was already, the prayer for interest has already been rejected by the Honorable Court in terms of explanation 5 of section 11. So, the petitioner is barred by res judicata, my lord, he cannot file fresh writ petition praying for the interest. This is the maintainability point, my lord, I am raising first, my lord. Kindly see the...
My lord. My lord, may I
Prayer
give the
A and
reply?
prayer B, she has prayed for interest in the earlier.
My lord, in the first occasion when the petitioner filed the writ petition, thereafter, my lord, the point was decided only it was true that there was twofold prayer, my lord. First for the compensation and thereafter, my lord, interest. Now, my lord, if the compensation has not been paid, my lord, the interest cannot be calculated. In the Rajesh's petition, my lord, the compensation was paid and thereafter the writ petition was.
I understand your condition. Listen to my order.
Thereafter, my lord,
The affidavit of
for calculation of the interest. My lord, thereafter, another occasion, state sought for time for calculation of interest. My lord, on third occasion, state came up this with this maintainability ground, my lord. My lord, thereafter, my
Take down. The
On the earlier occasion, my lords, the respondent 6 was directed to file a report in the form of affidavit. The report
I appear on behalf of the respondent number 6. But see, my affidavit, filing of affidavit will not help the, because I am representing West Bengal Mineral Development. The petitioner was a leaseholder in terms of 2002 rules.
If the respondent number
So what is your predicament in communicating the same to the coordinate bench?
No, see, after that it was came to me that
2 times has been granted time. In the last first occasion.
So who is the answering respondent, Mr. Banerjee?
State.
So
What is your prayer?
We have filed
so
report.
The writ petition may taken up any of the date. If they do not file the report in the form of affidavit, so writ petition must be taken up on any of the date.
Tomorrow?
Tomorrow.
Tomorrow, very good. Mr. Not this week.
14 হলো 15 হয়ে যাবে
15 এ কে আছে দেখি
নেই লোক নেই টাইম চাইছে
Not today.
হয়ে গেছে চলে আসুন
16, Lord, I appear on behalf of the
After a long time, I'm seeing you.
taking my Lord to the interim decision.
Give me a second, sir. Yes, sir. You are Mr. Chaturvedi.
Yes. That this lot relates to the renewal of lease, mining lease lot, in terms of the 2002 rule.
In terms of the 2002 rules, yes.
2002 rules. It has been declined in view of the amendment to the 2002 rules, whereby and whereunder now the 2016 rules have come.
Amendment or repealing?
Repealing, and the new rules will not coming into effect, which do not provide for any renewal, and 61 rule 61 provides for that even any application pending on the date would not be considered under the old rules. This is the sum and substance. Such an order is under challenge before my lord to this. My lord knows, my lord, that under the 2002 rules, Rule 12 provided for grant of lease, and 12 sub Rule 2 provided for a renewal. Now, Rule 12 provided for that the state would enter into agreement. This agreement, my lord knows that Article 298 and 299 of the Constitution, it empowers the state not to enter into business and trade and to enter into contracts. So the contract that the state enters into is not in exercise of Article 299 of the Constitution of India. This plot agreement provided for a renewal clause. But I say that notwithstanding Rule 61 of the 2016 rules not providing for it, my rights under the contract are guaranteed. That cannot be wished away, that cannot be washed away by taking an alibi that now there is no provision with regard to renewal in the 2016 amended rules.
Come tomorrow, sir.
So do I come back not after?
No, after from 2 p.m. I take up the contested matters. Come tomorrow, come tomorrow. আসলে লিখে নিন তো একটা হার্ড মিস
Lord, I know your lordship, my lord, but I am really in a very difficult situation, my lord. My matter is appearing under the heading for dismissal. But I do not find any indication of your lordship that as to when this matter can be called off. So really, if your lordship kindly indicate that when the matter will be called off.
Which matter? Which matter?
The one item number 162, the 182. Last occasion I appeared, then the other side was that's why lordship said that not today only.
182? You are for the petitioner?
I am for the petitioner.
এটা নিয়ে নিন তো আইটেম নাম্বার 182 করলেন just স্পেশালি ফিক্স পার্টার ম্যাটার কোথায় গেল উকিল বাবুরা তো তপন কুমার গুপ্ত ওইটা তো সেই ম্যাটারটা যেখানে ওই এগুলোর কথা চাইছি parties are not represented. Who is for the state? Serve notice.
I've already served my evidence of service on Washington. My lord was an order directed the department to forward a copy of the order and fix the date on 20 April 2025 under the heading specially fixed matter.
নোটিশটা যায়নি কিন্তু ডিপার্টমেন্ট থেকে চেয়েছে অ্যাপোলজি চেয়েছে আসুন the taken up 2 p.m. sir. From 10:30 a.m. I take up the motion matters.
My lord, 183 I am for the state man.
183
টা কি হলো? ও এইটা ব্যাপার না ওটাই তো কিছু স্যার
No order of dismissal was 182. I have fixed a date for hearing. Date বলে দাও না
I am not a 183.
Oh, I see.
I am 183.
Yes, call the next matter.
Number 151. 142. 151 I am for the statement. 146. 151. Yes.
Better না আমাদের
Number 146.
I have kindly Mr. Lordship fixed the matter on 13 May. I have already talked with Mr. Talenos Siddiqui appearing on behalf of the respondent.
The matter is given for a considerable length of time.
at some, the mean that it was
On several occasions, Mr. Paul, matter is being going to be adjourned. Or changed for a very long time, no?
But 13 May much it's for
13 May.
13 May, so share 2 PM. 2
Mr. Paul, learned advocate appearing on
Yes, my lord, I am for that state. You কি বললো? আসছে।
You are for the petitioner, sir?
I am for the state, my lord. Union of India has come.
Mr. Ray for the Rai for the petitioners, Mr. Dey for state, and Mr. Indrajit Dasgupta for the respondent 1 to 5. Has it been heard?
Yes, my lord.
Just on the previous occasion, just my lord, not entirely, just I have started. Just I have started.
And order was passed also on that.
That I've seen.
We are also human. Yes, ma'am. Yes, ma'am. This is why I request the member of the part to complete the case.
Yes.
So that I can pass before the demand. My lord, this is a short matter, my lord. That is, my learned friend wants to take some. My lord, Union of India, my lord, take the point that there is a provision of appeal. So, my
No,
lord,
no, that is not the issue.
your lordship, custodian of the
Lordship, I have lost the question. I have given this particular paper, my lord. Would your lordship get it?
Yes. Enemy property, my lord. He is a custodian. I am the assistant custodian.
ठीक है. Yes. Yes.
Yes, Mr. Rai.
My lord, kindly takes the trouble to see this particular
List of dates, no? Yes, yes. You have referred.
Yes.
Yes, sir.
What happened, my lord? The issue is Enemy Property Act. That our case is that, specific case is that this particular property belonging to Indian citizen and all the transfers made by and between Indian citizen. Therefore, the question of vesting under the enemy property does not arise. This is the precise number, first one. Second, my argument is
Transfer between the citizens of India.
yes, all transfer, initial ownership followed by subsequent transfers were made by and between Indian citizen. Therefore, Enemy Property Act does not attract in the present case. Second point, question, to declare a property as enemy property, it must follow a notification followed by order on that account. Authority has to first ascertain that this particular property covers enemy property. Then there has to be a notification, then consequential actions. I'd be showing from my document below. As such, in the notification that has been supplied to me does not cover the land in question. Then what is the enemy?
Respondent Ms. Sushmita Shahadatta is appearing, my lord. She is appearing before another coordinate bench, my lord.
My lord. Then what is the enemy property about, my lord? What happened, my lord? In course of Chinese aggression, the authority considered, or rather government considered, some properties which is this Pakistani nationals property, which is left out in India, in substance, my lord, which was left out.
Please inform that this court is not reluctant to grant any adjournment. Ask your senior to come as soon as possible.
In 65, my lord, following Chinese aggression, the legislature considered it necessary to enact a law which has been subsequently enacted as Enemy Property Act, whereby, my lord, the certain properties which belonging to Pakistani nationals, which was under our country, my lord, that property has been declared as enemy property. Enemy property, I'd be showing defined. In substance, property belonging to Pakistani national, that property will be declared as enemy property, and those properties, my lord, will come under the custodian of enemy property.
Custodian of enemy property is a functionary of the state or functionary
No,
of the
Union of India, it is under the Ministry of Home and Affairs. And each district magistrate is the custodian of the district. Yes, each district magistrate acts as a custodian of enemy property in a district, and there is a separate department in Calcutta also, my lord. And I had the opportunity pursuant to this.
According to you, with the enactment of that act, the property goes to the hands of the custodian of the enemy.
Yes, by implication
who is a functionary of the Ministry of Home Affairs.
Ministry of Home Affairs.
Then what is the role of the district magistrate, sir?
District magistrate acts as a custodian for the district concerned, my lord, by instruction. And there is a department, my lord, in the state also. But functionaries, so far custodian, act as a district-wise, DM has given the authority some power. Then, my lord, before I will refer to this, just I am summing up the issue. Then what happened, my lord? One Sayyid Fateh Ali Mirza
Yes.
was the CS recorded owner of the subject property.
Yes.
What he did, my lord, in 1952, he transferred the interest of certain properties in favor of his wife and two daughters.
By executing a registered
deed of Hebanama.
Yes.
Then, my lord, one of the daughter in turn transferred it in 1973. I'd be showing to your lordship to one Mehboob Ali.
Yes.
Then, my lord, in 1998, Mehboob Ali transferred it to in favor of our petitioners, my lord. When after the deed was executed in 1978, my lord, we had been to the office of the BLRO for the purpose of its mutation. Then we came to know that property has been vested and recorded under the enemy property, in the name of enemy, custodian enemy property.
Mehboob Ali is the lead petitioner before this?
No, Mehboob Ali transferred in favor of my petitioners, my lord.
Oh, I'm sorry.
Yes.
Mehboob Ali to the lead petitioners.
Yes.
And when the lead petitioners approached the land and land revenue department,
For
you
the
came
purpose
to
of
learn that it has been recorded as enemy property.
enemy property. Then, my lord, we raised the objection to the enemy property wing. Raising objection, this cannot be, because it is our property, transfers made between by and between Indian citizens, my lord. Then nothing was done. Then we moved a writ petition before this Honorable High Court.
The petitioner raised objection under section Ato owned by the Indians and all transfer by Ato cannot be considered as enemy property within the meaning of non-consideration of Honorable Court was moved in the earlier round of litigation.
Yes.
Yes.
Then Honorable High Court substantially accepted that there was a direction to file affidavit. They did not file it.
Take a decision.
No, there was certain observation also. Take a decision that if any unimpeachable document is available to them, then they can go. Otherwise, my lord, court holds that since there was no affidavit on their part, it is a by and between Indian citizens, cannot be said to be in enemy property. But if he has got any unimpeachable document, they can rely upon. Then there was hearing before the Delhi, my lord. There was non-compliance. I have to move the application for contempt. Ultimately, a decision taken. Decision taken only on the score, my lord. I will be showing to your lordship specific, according to them. In 1952, Sayyid Fateh Ali Mirza, 1950, before 1952, in 1948, that Sayyid Fateh Ali Mirza expired. Therefore, question of execution at the instance of Fateh Ali Mirza, who died in 1948, does not arise. Therefore, according to them, they are questioning the very existence of the first deed. Therefore, everything goes. Then what they relied upon in proving that the 1948 Sayyid Fateh Ali Mirza died, they relied on one-page publication of a book.
One page?
One page of a book. A book, yes, I will be showing. A book was published from America, where it is written that in 1948,
With no intention to disturb, he must make clear
But
who
he-
has written the book.
I everything. Just I am summing up the matter, so I have to rely on document. I will show every document to you. There was a publication of book which published from America. A page shows where it is written that Sayyid Fateh Ali Mirza died in 1948 without mentioning any date, month, etc., etc., etc. On that score, basically on that score, they hold it. If the 48% died, Therefore, there cannot be any question of execution of any deed from 1952 from which subsequent interest has been devolved. Basically, I do say on that score, our application has been rejected. Then, without challenging that decision, I have come up before the Honorable Court. There was direction for affidavit. Affidavit has been exchanged. After filing of affidavit, they considered it necessary to have a leave of the Honorable to file supplementary affidavit of opposition. That has been replied. This is the substance of the case about.
Mr. Roy, I'm asking you a question.
Yes.
Don't think that I have framed my
No.
mind. Just for academic purpose, I'm asking a question. In the event the respondent Union of India has placed reliance upon a document, and on the basis of that document, it comes to a finding that the original owner, Syed Fateh Ali Mirza, died prior to the execution of the alleged Hebanama. That means they are practically challenging their right and interest in the property.
Yes.
Though in the subject
Yes,
matter, the subject matter of the instant writ petition is that whether the respondent authorities are justified to deny the mutation or not.
Yes. No.
What I'm on, I'm asking this question, then reply. In the event your right, title, and interest is at the stake, why have not filed a suit for declaration injunction before?
This is my subject. Yes, I know, my lord. I am to come across this question. It is not at all necessary because of the fact owners upon whom they are relying on a publication of book. I am armed with a registration of a document. Then, if two things are available, I have got a document registered. They are disputing it, relying on a publication in a book.
Exactly, I am on that point, Mr. Dai.
So who is to file the suit?
Can a read court go into that?
My submission would be read courts will not go into this question. Read court will decide on the basis of the available record and the issue involved, taking into consideration the judgment passed initially by that concurrent bench with the finding that how it is to be decided. Court has framed something that on the basis of this you are to decide. That is not appealed against. Now the question is,
in the event the Union of India places reliance upon a book and came to a finding that the original owner, Syed Fateh Ali Mirza, died prior to the execution of the alleged Hebanama.
Yes.
Does it not touch you? Does it not touch
Yes,
the
it
right
is
and
touching my
interest?
but mayor saying, why do I have to go? Onus is upon them. Onus is upon them to prove it.
Kindly recollect the provisions of the West Bengal Land Reforms Act.
Yes.
Where in case a mutation is denied, the civil court has got no authority to take.
No, I am not on mutation.
The civil court has right. Civil court has a right to still right under the specific act to make a declaration on declaratory degree.
Yes.
And on the basis of that declaratory degree, you can approach the appropriate authority for mutating your name.
Yes. I am not.
You are challenging the order of refusal of mutation.
No, I am challenging the declaration of vesting. Had it been a case that I applied for mutation, I could have petitioned, then I had to go to the West Bengal Land Reforms Tenancy Tribunal. That is the forum.
Place your case, sir.
That is the forum. Here, my prayer is that you cannot vest a property under the Enemy Property Act, which practically belonging to an Indian citizen. And Act says so, judgment says so. I was referring. And number one, right from 2005, my lord, inter judgment with me, it has specifically hold the custodian and enemy of property cannot have the entire title and ownership. They are for the time being retaining possession.
Just like a manager.
Just like manager, managerial capacity. Number two, to declare a land to be vested under the Enemy Property Act, there has to be a notification. There has to be a fact finding.
Come to the point.
I will point out one thing, the vesting was not done recently. Vesting was done in
They
1964.
let them show that it has been
You will
vested.
get your chance, sir. You will get your chance.
They has to show that it has been vested. Any document to show that it has been vested. Then Lordship just Your Lordship kindly turn to page 71.
Madam, in one matter, in the morning, in the forenoon session, I have asked the writ petitioner's and learned advocate to implead National Highway Authority and to serve a copy and with a direction to the National Highway Authority to regularize your appointment. Kindly take note of that.
Item number 1. Mention this matter and I don't have any idea about the mention. So Lordship kindly recorded my name and item number 183. Out of turn already mentioned. I don't have 183.
এই কোনটা হয়েছে গো মিস্টার পান হ্যাঁ নিয়ে নিতে পারবো নামটা নিয়ে নিতে পারবো ইয়েস ইয়েস টেক ডাউন ওনার নামটা নিয়ে নিন এমএস রয় মিস মনিকা রয় না ইয়েস স্যার মিস্টার রায়
Yes, my lord. But since this admitted position from page 25 of the writ petition, my lord, to page 55, page 25 to page 25. I will not trouble to your lordship. They are not disputing that this has not done. These are all documents of title, deeds as I have referred, my lord.
Page number 25 to 23 to 25.
25 to sale deeds.
Are the chain deeds?
Chain deeds.
Chain deeds.
Yes, from CS record to chain deeds. Page 25 to page 49.
No, page number 23 to 25 what?
No, not 25, my lord.
Oh, I'm sorry.
From
Then,
page 25.
just a minute. Sorry. Page number 25
to page 49. It covers my title coming
page
from
number
CS
25 to
49.
49.
This covers my related title to the property. How the change deeds are coming, how we have acquired title. These are undisputed questions.
So 25 to 49 are the relevant chain record of rights
and
along with
titles.
deeds of title.
And titles.
Yes.
Then page 50, this is my objection to the authority.
Objection with regard to the vesting and recording of land as any property under
Yes.
property.
Then, my lord, page 50.
Objection by the writ petitioner.
Yeah. Then page 56.
Page number 56.
This is my RTI.
এই কল্যাণ বাবু আমাকে একটু এদিন না কিছু ফ্ল্যাগ দিন না ভাই পেজ নাম্বার
56 annexure P7.
Page number 56. What is that?
My lord, this is my RTI application. My questions, lordship, kindly allow me to read it.
56 is the reply.
Reply
to your RTI.
RTI. It incorporates question also. Whether the land referred to in the land schedule below have been declared vested in the custodian of enemy property for India, if vested, the date of vesting. Number answer, yes, date of vesting 10/9/1965. Lordship, kindly according to them. Whether any Second question, my lord, whether any central government notification has been published declaring the referred property as vested in the custodian of enemy property for India, and the date and number of such notification, and supply me the copies of the central government notification published in the regard. Answer: yes, notification number such and such dated 10/9/1965
and 11/9/1965.
Therefore, supply me the copies of the copies enclosed. Copies enclosed. Then these are the copies supplied to me. Next page, my lord, page 78.
Page?
Next page, my lord, page 57. I'm sorry. Next page, page 57. In exercise of power, this is the notification according to them, of the power conferred in sub-rule 1 of Rule 135 Roman 5 of the Defense of India Rule 1962, central government hereby orders that all immovable property in India belonging to and held by and managed on behalf of all Pakistani nationals shall vest in the custodian of enemy property for India with immediate effect. Nothing in this notification shall apply to any such property belonging to or held by or managed on behalf of Pakistani nationals as are employed in the different missions of the government of India. This is the notification. Then, Lordship, next page, 58. In exercise of powers, that is 10th December 1996, in exercise of powers conferred under sub-rule Rule of 151 Defense of India, the central government hereby directs that all enemy property as defined in clause 4 of the said rule, whether movable or immovable, belonging to and held by managed an enemy defined in clause B and C of 130 of the said rules, an enemy subject defined in clause. Then, Lord, next page, Lordship kindly sees. Page 59. In exercise of power, conference, such as I am skipping over line, then schedule. All lockers, safe deposit in vaults of commercial banks, exchange bank, anybody, person doing banking business, and any order or person renting out lockers, all negotiable instruments such as promissory notes, such as all vehicles. Therefore, my lord, I don't find a semblance of the schedule from which my land is covered by notification, it is stated.
The general notification.
General notification, but I would be showing, my lord, even if there is a general notification, there has to be a fact finding. They cannot pick up someone, say this is in Pakistani national property. There has to be a fact finding. I understand, my lord, this general notification says all properties of
the territory of the India.
Pakistani national will vest under any will. But to identify it, that it is its particular property belongs to a Pakistani national, there has to be a fact finding.
Of course.
Otherwise, my lord, it is redundant. I could have. Therefore, schedule doesn't contain. I wanted to know at least the notification and the answer to me is completely.
Your question is how they come to a finding that is it belongs to an enemy.
The enemy, it belongs to
an enemy
Pakistani national.
Now
Therefore,
it falls under the enemy property.
Yes, there has to be a fact finding decision, and I am also supported by decision. High Court also said in a similar situation, mere notification will not do. You can have a general notification, but notification to act on the notification, there has to be a specific fact finding. Then you can hold it, then it is a vested property. Then, Lordship, my lord, read petition, order of the Honorable Court. Page 65. Just I am reading, my lord.
Give me a second. Yes.
This application, just I am reading, my lord, this application under Article 226 of the Constitution of India impeaches the vesting of land stated to be that of petitioners by a notification dated September 10, 1965.
Yes.
At the outset, it must be recorded that despite two opportunities, the respondents did not file any affidavit in opposition, though served. Therefore, even though I was waiting with eagerness to hear Mr. Dasgupta, learned advocate on the facts on behalf of the central government, unfortunately, I am restrained by procedural law from doing so. So we'll have to proceed on the basis of the pleadings contained in the writ petition as if they were gospel truth. From the writ petition, it appears that the petitioner is a transferee of a citizen of property. He claims that, unfortunately, sometimes in singular form it has happened, owing to unfortunate death of the he claims that as citizen, this property would not never been recorded as enemy property. His further submission is that this property does not figure in the schedule. His last submission is that no copy of any order under Section 7 of the Act was ever served upon him, nor was given any opportunity to contest any proceeding in which the property was declared to be enemy property. He submits that he had no notice or knowledge of the so-called declaration by his property as enemy property before attempting to get the land mutated in his name. When the revenue officer concerned mentioned that it was not possible to mutate the property in his name since it was recorded as an enemy property, it was only then he made a request under the provisions of the Right to Information Act 2005. The assistant custodian of enemy property by letter dated December 8, 2008 informed him that the land had vested in the central government by a notification of September 10, 1965. In this petition, he has challenged the said notification. The contention that a citizen, his property could never have been treated as an enemy property, and or that his transfer having been a transferor having been a citizen of India, the property could never have been treated to be enemy property, proceeds on the basis of the provisions of the Enemy Property Act 1968 as it stood before the amendment of 2017. Before such amendment, the definition of enemy in clause 2b included a citizen of India. On that basis, several judgments of the Honorable Supreme Court had been rendered, which clearly laid down the law that the definition of enemy provided under Section 2b excludes citizen of India as an enemy or enemy subject or enemy firm. One of the judgments cited in his behalf in the case of Union of India and another versus Raja Muhammad Amir Hussain Muhammad reported in AIR 2005 Supreme Court such and such. Thereafter, on 2017, Act 3 of 2007 made a sea change to the definition of enemy under Section 2b of the Act with retrospective effect from. I am skipping over, I will show that Act. It could have been argued that since the retrospective effect was with the effect from January 7, 2016, the petitioner who purchased the property on December 30, 1998 from his vendor who had purchased the property in 1973 pursuant to transfer made to him as vendor in 1953, when all of them were citizens of India, the property could not be enemy property. Unfortunately, the amended Act 2017, that the Enemy Property Amendment and Validation Act 2017, which enacted on March 14, 2007, contained, therefore, my lord, Inter Act has been given. The words shall be substituted and shall always be deemed to have been substituted appear to indicate that this provision takes effect on the date of 1965 Act was enacted, not just from January 2016. So
retrospective effect.
So in order to abate applicability of the statute, a person would have to show that the person transferring or owning the property was not a citizen of India, being the legal heir or successor to any enemy.
So in order to avoid the applicability of this statute,
yes,
a person would have to show that the person transferring or owning the property was not a citizen of India, being the legal heir or successor to an enemy or enemy subject. And the plain reading of the said provision of the Act means that a finding of fact has to be recorded that the owner of the property or the subsequent transfer were never an enemy or a legal heir of the enemy, even though that person could have been a
Yes.
citizen of India.
Here I would be showing, my lord, admitted position, my lord, admitted position. It was not that the successor came into picture. I will be showing.
Give me a second. Oh, it means that even if a person is a citizen of even if the vendor or his legal heir a citizen of India, in the event his predecessor is in a citizen of an enemy, in that event this act will apply.
Yes, I was showing, my lord, this is not my case because my case is simpliciter. The property owned by a citizen.
Then whatever, place the judgment.
In such view of the matter, despite taking the statement contained in the writ petition as true and correct, I cannot, for the first instance, take a decision as to whether the property be the enemy property, nor can I, in all fairness, ask the petitioner to approach the forum under Section 18 of the Act to redress his grievance, because in doing so, the order of vesting must be first served on the petitioner so that he can make a representation, and it is no longer open to the respondent to dispute that no such copy of the order was served on the petitioner. If I accept that if I approach the petitioner to approach the authority under Section 18 of the Act, there will be a question of limitation, since the limitation runs either from the date of service of order or from the date of publication of the notification. However, it appears from the record that the petitioner made a representation on November 8, 2018 to the respondent authorities, but no response was given thereto by the authorities. AIR 2005 SC 4383, being the case of Raja Muhammad Amir Hossain Supra, itself records the concern of the court about the dangerous attitude resulting in doing the institution damage, which is developing that the justice is required to be done only the court. This attitude is betrayal of constitution as well as laws. Every and any authority working under the statute has to discharge its duties in a just manner, otherwise people will lose faith in governance. In such view of the matter, regardless of limitation, the representation of the petitioner must be considered and disposed of in accordance with law, keeping in mind that the case that the petitioner and the transferee are all citizens of India, not enemy, which has not been controverted and cannot be disputed in the eye of law. Lordship, kindly take notice of it. In view of the fact that no affidavit in opposition was filed, however, if the respondents have records which are unimpeachable and which show otherwise, respondent number 2 shall be entitled to take a decision in accordance with law, even if it is against the interest of the petitioner. The entire exercise must be completed within a period of 2 months from the date of communication of the order. The petitioner shall be given further opportunity of hearing heard. A reasoned order shall be passed, which shall be communicated. This was the writ petition about my lord. Pursuant to this direction, my lord,
yes,
we have to attend the Delhi Home Secretary Department, my lord, where I'm not P9, page 73, written notes of submissions to be filed. We have filed on behalf of custodian and enemy property, also written statement filed, page 92.
So what is the order?
Then Lordship
Page
kindly.
167.
Yes.
Page 167.
Yes, this is the order.
Yes.
Whereas the applicants herein, namely Asfakul Haq and others, have made the present represent
Asfakul is the read petitioner.
Asfakul and others.
They are the read petitioner.
They are the read petitioner. Whereas the applicants herein, namely Asfakul Haq and others, have made the present representation dated 8/11/2008, being agreed by the order of custodian enemy property for India called ATO, issued by the whereby the subject property has been vested as enemy property in the CPFI under the provisions of Enemy Property Act as amended by the Enemy Property. But starts with the wrong interpretation. There was an order I have challenged. I had been through that pursuant to direction of the Honorable Court.
Yes, sir.
Then, my lord, then quoted Section 18 of the Enemy Property Act, which provides that the central government may, on receipt of a representation from person aggrieved by an order of vesting or property as enemy property in the custodian within a period of 30 days from the date of receipt of such order or from the date of its publication in the official gazette, whichever is earlier, and after giving a reasonable opportunity of being heard, and if it is of the opinion that any enemy property vested in the custodian under the Act and remaining with him was not an enemy property, it may, by general or special order, direct the custodian that such property vested as enemy property in the custodian may be transferred to the person from whom such property was acquired and vested in the custodian. Whereas the applicants, through their representation dated 8/11/2008, have made the following prayer. Number one, to set aside and recall the decision order of vesting of such land as enemy property under the Enemy Property Act 1968, to divest the said land and pass appropriate order in this regard, issue necessary instructions ordered to the appropriate authorities for correction of record of rights, deleting the recording of enemy property in the respect of the referred land from the record of rights. Whereas during pendency of the said representation, the applicants have filed writ petition before the Honorable High Court of Calcutta, bearing number which has been disposed of by the Honorable Court by order dated 2011-2009, directing the central government to consider the representation within 2 months from the date of court order. The applicant has also filed a contempt petition bearing number such and such, which is pending before the Honorable Court. Whereas, as per provisions contained in Section 18 of the EP Act 1968, as well as in the transfer of property vested as enemy property in the custodian order 2018, opportunity of hearing was offered to the applicant. The office of the CPPF Kolkata branch filed written statement on such and such, refuting the applicant's claim being devoid of merits. The summary of the contention raised by the CPF Calcutta bench as submitted through its written statement is as under. Then there, my lord, by virtue of Gazette notification dated 7/6/2003, all district magistrates and district collectors have been designated as ex officio deputy custodian of enemy property for preservation of the properties failing within their territorial jurisdiction. Hence, the district magistrate Murshidabad was empowered to issue direction for preservation and management of the property in dispute. In exercise of the power conferred to the custodian of enemy property for India under Section 8 of the Enemy Property Act 1968, with the approval of the Government of India, custodian of enemy property of India had issued guidelines on how to preserve and manage immovable enemy properties vested in the custodian by standing order dated 18/11/1971 and standing order number such and such 17/4/2000, which were circulated to the state district level officers all over India, and these orders cover almost every aspect of the enemy properties work entrusted on them. Since the enemy properties are to be preserved and managed by the district authorities on behalf of the custodian of enemy property for India, they have been authorized to take such measures as they consider necessary or expedient for preserving the interest of the custodian of property of India. prior to issuance of the standing order by virtue of Defence of India Act 1962, followed by the Enemy Property 1968 as amended time to time, the district authorities, district magistrate, district land reforms officer, JLRO, etc. were empowered to maintain, preserve and manage the enemy property situated under their jurisdiction with the approval of CPFI. The immovable property located at district Murshidabad under various moujas as mentioned hereinafter originally belonged to and recorded in the land revenue records, RS record, at the material point of time, that is 10/9/65, in the name of Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, who had left India and migrated to Pakistan.
Kindly pause here.
আমি তো বলছি রে ভাই
না না তাহলে আমাকে পুরো বলতো আমাকে 2 ঘন্টা নিতে হবে এই
নেবে?
জায়গায়
কি হয়েছে তাতে অসুবিধা কি
Well,
আছে?
it was all along the case.
I am reading.
It was recorded in the name of
Yes,
Sayyid
yes,
Fateh
yes,
Ali
sir.
Mirza.
Yes.
Now this order says
I would,
it was recorded
yes,
in Sayyid relevant point of time.
Yes.
Son of. He has shown documents which
I have not shown document. It is the recorded submission of the custodian. I have not.
which
I am reading it. What do you say? I have not. shown any
Mr. Rai, please
document.
proceed. Please proceed.
What you have submitted that has
Mr.
been
Rai,
recorded.
please proceed. Mr. Rai.
Who left India and migrated to Pakistan and became.
Just a minute. The immovable property located such and such under various originally belonged to that is on Atto in the name of Sayyid Iskandar Ali Mirza.
Yes.
Son of
Fateh Ali Mirza.
Fateh Ali Mirza, who had left India and migrated to Pakistan.
Yes.
And
Yes.
became the first president of the ministry.
Yes. I am making it clear to your lordship for your lordship.
Very good. Then
Fateh Ali Mirza, according to me, was original owner, and according to them, this Iskandar Ali Mirza happens to be one of the son of Fateh Ali Mirza who migrated to Pakistan. My case is that Fateh Ali Mirza, since transferred in 1952, question of any ownership by rest
very
does.
good. Please the order first.
Acha.
Then I shall
Yes, sir. The details of the hence the immovable property owned by migrants was
according to them.
Yes.
The properties of different moujas recorded stood recorded in the name of Sayyid
Iskandar Ali Mirza,
son of Sayyid Fateh Ali
Yes, yes.
Mirza.
Yeah.
As on 10/9/65, who left India and migrated to become the first president of
Yes,
Pakistan.
according to them. Yes.
Hence,
the immovable property owned by migrants was automatically vested in the custodian of enemy property for India under notification dated 10/9/1965, issued in exercise of powers conferred by Sub-Rule 1 and Rule 133 of the Defence of India Rules 1962. The details of enemy property situated in Mauja, Golabagh, Hossain Nagar, Sajansa district owned by Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, declared as enemy property is as under. Then, my lord, they have given a chart. See, Sayyid Fateh Ali Mirza, I am keeping over, my lord, that chart. See, Sayyid Fateh Ali Mirza, that is alleged executor of the Hibanama, dated 10/12/1952. Now the question, my lord, what I was trying to, according to them. Sayyid Fateh Ali Mirza, alleged executor of the Hibanama, dated 10/12/1952, died in the year 1948. Which was much prior to the date of execution of the alleged Hibanama. The date of death was duly certified by Sri Jayanto Mondal, WBCS Executive Estate Manager, Murshidabad, Estate Judicial Department, Government of West Bengal, a statutory body. Based on the such information, it is clear that Sayyid Fateh Ali Mirza was not alive during execution of the said alleged Hibanama. The submissions of the applicants counsel that though the local inquiry, they have learned that probably Fateh Ali Mirza expired in the year 1959 or 1960 is nothing but a concocted, a fabricated statement without having any legal base and authenticity.
what does it mean? The submission of the appellant's counsel.
Yes.
Through the local inquiry.
Yes.
They have learned that probably Fateh Ali Mirza expired in the year 59 or 1960 is nothing but a concorded fabricated statement without having any legal basis or authenticity.
Hence, the genuineness of the Hebanama is itself questionable, and the same is nothing but a false, fabricated document and void ab initio and having no legal implication. Not only the genealogy and relationship as mentioned in the alleged Hibanama was totally wrong as compared to the genealogy provided by the statutory body, Estate Manager, Murshidabad, Estate Judicial Department, Government of West Bengal. The subject property in the CS era belonged to Sayyid Fateh Ali Mirza. After his demise, the property was devolved upon his ancestor. Being in successor in interest, the subject property, along with other properties in the name of Sayyid Fateh Ali Mirza, were devolved upon Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, as inheritance. The name of Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, was recorded in the RS Record of Rights. Subsequently, after his migration to Pakistan, all the properties owned by Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, were vested under the custodian of enemy property by virtue of notification dated 10/9/95 issued in exercise of powers conferred by Sub-Rule 1 of Rule 133V of the Defense of India Rules 1962. That as per the provisions of Section 22A of Enemy Property Act 1968 as amended by Enemy Property Amendment Validation Act 2017 shows that subclause A provides that the provisions of this act as amended by the Enemy Property Amendment and Validation Act 2017 shall have and shall always be deemed to have effect for all purposes as if the provisions of the act as amended by this act had been in force at all material point of time, which shows that Enemy Property Amendment and Validation Act 2017 is giving retrospective effect to the provisions of EP Act. Further, by reading of the provisions of the Section 22 of the Enemy Property Act 1968 as amended by Enemy Property Amendment Act 2007 shows that subclause C provides that no suit or other proceeding shall, without prejudice to the generality of the foregoing provision, be maintained or continued in any court or tribunal or authority for the enforcement of the decree, order, or direction given by such court or tribunal or authority directing divestment of the enemy property from the custodian vested in him under Section 5 of this Act, as it stood before the
Just a minute, sir. Further, we are reading of Section 22 of the ATU as amended by Enemy Property Act shows that subclause C provides that no suit or other proceeding shall, without prejudice to the generality of the foregoing clause, be maintained or continued in court or tribunal authority for the enforcement of a decree or order or direction given by such court or tribunal authority directing this divestment of any court. Yes.
And such enemy property shall continue to vest in the custodian under Section 5 of this Act as amended by the aforesaid Act. As the said section as amended by the aforesaid Act was in force at all material times. Section 22A within bracket D provides that any transfer of enemy property vested in the custodian by virtue of any order of attachment, seizure, or sale in execution of decree of a civil court orders of any tribunal or authority in respect of the enemy property vested in the custodian, which is contrary to the provisions of this Act as amended by the Enemy Property Amendment and Validation Act 2017, shall be deemed to be null and void, and notwithstanding such transfer continue to vest in the custodian under this Act. The CEPI Kolkata branch also relied upon the Section 6 of the Enemy Property Act and submitted that subject immovable property will remain so vested in the said custodian till its disposal by the central government under Section 80 of the said amended Act and guidelines framed thereunder. Whereas in response to the written submission submitted by the CEPI Kolkata branch, the applicants also filed their additional written submission dated 11/8/2023, which was received through email dated a summary of reply submitted by the applicants through their additional written statement reads as under. Regarding alleged death of Sayyid Fateh Ali Mirza in 1948 and execution of registered Hibanama in 1952 as raised in written statement. To substantiate the death of Sayyid Fateh Ali Mirza in 1948, the concerned authority has relied upon the referred book, which was published from America, and alleged author is a foreign national. To substantiate the death of Sayyid Fateh Ali Mirza in 1948, certain pages of the said book have been referred to and relied upon, but the referred pages did not mention the date, month of the death of Sayyid Fateh Ali Mirza. Therefore, on the face of record, the alleged year of death without including the date and month of death is vague, indefinite, baseless in accepting the actual death of a person. Such statement cannot be accepted to substantiate, to substitute the death of a person in 1948 as alleged. Apart from the same publication statement in the referred book on the date of 1948 is not supported by any documents, far less of legally acceptable documents in this regard. The referred book is unauthentic. No reliance can be made on such publication in such a book, being personal in nature. Mere statement publication in such a book about the death of a person is not legally acceptable. Such book not acceptable as public documents within the meaning of Section 74 of the Evidence Act. In the written statement to prove the death of Sayyid Fateh Ali Mirza in 1948, the report dated 18/5/2023.
Just a minute, Mr. Rai. Then who has referred this book?
On their part, I have not referred it.
Achha.
They have relied upon a report of a.
It was not accepted.
No.
Very good. Then
in the written statement to prove the death of Sayyid Fateh Ali Mirza in 1948, here, my lord, my additional submission has been recorded. They are not the finding. This is not the finding. In the written, Lordship beforehand,
the summary of the reply.
Summary. They are quoting it. In the written statement to prove the death of Sayyid Fateh Ali Mirza in 1940, the report dated 18/5/2023 of the estate manager Murshidabad has been relied upon. In this respect, it is stated that report of the estate manager is based on the same referred book. No other authentic, legally acceptable document in this regard has been referred to and furnished. Therefore, such statement report is not acceptable. Furthermore, the estate manager is not legally authorized and competent to certify the death of any person. In the context above, it is relevant to mention herein that the deed of Hibanama dated 10/12/1952 is a registered document. For the purpose of registration of a document, conveys the executant of the document has to attend the concerned register in the registration office, and in his presence, the executant signs the document. And following procedure, the instrument is registered and treated as public document. Hibanama is deemed to have been accordingly registered in the presence and by signing of the executant before the register.
A registered deed of Hibanama is not a public document. It is a registered document.
I say so, Lord.
No, it has been recorded, is treated as a public document. It's not a public document.
But what I wanted to mean that it is available at least.
I understand.
Presumption of execution followed by a registration of a document is accepted as the execution of proper document at the instance of a living person. That it has been established by the rulings of the Apex Court of Accounting that a document is presumed to be genuine if the same is registered. Reference, I have referred on rulings. In this context, it is also pertinent to mention herein that to disprove a registered Hibanama, onus lies upon the person who disputes such registered instrument by a cogent and legally enforceable document having evidentiary value and through competent court of law. Merely by surmises or conjectures, such statements and allegations cannot be established. Under no circumstance, a publication in a book which has got no evidentiary value can override the legal value of a registered document. In this context, above it is relevant to refer herein that by the referred registered Hibanama, Sayyid Fateh Ali Mirza gifted some properties to his wife and two daughters, Kazmi Bibi, wife as Doni number 2, who got the subject property described in cost schedule of the deed. Subsequently, in 1973, Kazmi Bibi, by registered deed of sale dated 3/8/1973, transferred her interest in the subject land in favor of Mehboob Ali, who transferred the land to the applicants by registered deed on 13/12/1998. Applicants are bona fide purchaser against valuable consideration. It is categorically stated that deed of Hebanama is authentic, valid document. It has been duly executed, registered, and acted upon in terms of subsequent transfer of interest by subsequent registered deed executed and registered in 1973, 1970. On the question of that was the written submission. Then, my lord, regarding incorporation of name of Iskandar Ali Mirza in record of rights, ROR. Since Sayyid Fateh Ali Mirza, original owner, bequeathed the subject property in terms of registered Hebanama dated 10/12/1952 in favor of wife Iskandar Ali Mirza. According to them, Iskandar Ali Mirza did not acquire in the interest in the property.
Your submission.
Yes, that has been recorded. Petitioners are bona fide subsequent purchasers of the land in 1998. Before that, there were two transfers in 1952, Hebanama in 1973. All are registered documents. Following transfer of such interest by the original owner in favor of wife, Iskandar Ali Mirza did not and cannot acquire any interest in the property. As such, recording of name in ROR was absolutely illegal, having not acquired any successory right. Apart from the same, as stated in the written statement of the CPI, Iskandar Ali Mirza, Pakistani national, left India, migrated to Pakistan, and was there at Pakistan, holding certain posts. As such, question of retention of possession of such person for the purpose of recording of ROR does not arise, as ROR implies possessory right. On the face of it, it appears that preparation and recording of ROR in the name of such person who did not acquire any successory right and also did not maintain possession of land in any manner is absolutely illegal, baseless, and no reliance can be made on such document prepared in the absence of any legal right and retention on possession. It is disputed that the said name of Fateh Ali Mirza was recorded in RS record as alleged. Regarding the last million, regarding the statement made in the written statement of CPI, Kolkata Branch, to the effect that applicants failed to produce any cogent evidence about the death of Sayyid Fateh Ali Mirza. It is stated that neither the applicants nor the landed advocate took the responsibility to substantiate the death of Sayyid Ali Fateh Ali Mirza. Same was not necessary for the applicants. Only in response to the query by later dated made by the concerned enemy property wing, by later dated to Sajan, it was intimated that date of certificate of Sayyid Fateh Ali Mirza was not available to the applicant, but on local inquiry it is learned that the said person probably expired in the 1959-96. The said letter is a part of record. Regarding inclusion of property, enemy property, White Gazette notification 1965 and its vesting, there cannot be any automatic vesting of property without any fact-finding or decision or order on vesting of property under the Act. Admittedly, no document is forthcoming to show that before vesting of such land, any fact-finding and decision was made, order passed on the basis on relevant sections of the Act, and satisfaction of as laid down criteria specified in the Act. As per information supplied on the RTI Act, schedule of vesting property does not contain the referred property. In this respect, it is pertinent to refer the reported judgment of 1977 to CLJ of the Honorable High Court of Calcutta, which has already been supplied. It is held that in the said ruling that in order to attract Section 5 of the EP Act, it must be shown that there was an order by which the properties were declared to be enemy property, and without such order, the property could not have been vested as enemy property here. And whereas up to this, my written submission in substance has been recorded. Then, my lord, whereas the CEPI has also submitted its issue-wise reply, which was taken on record on the hearing dated 8, 2003. Relevant portion of the reply given by the CPI is reported as under: owner is an enemy or not. That immovable property located at district Murshidabad under various moujas as mentioned herein under originally belonged to and recorded in the land review RS record of rights at the material point of time, that is on 10/9/65, in the name of Sayyid Iskandar Ali Mirza, Sayyid Fateh Ali Mirza, who had left and migrated to Pakistan and became the first president of Pakistan. Hence, the immovable property owned by the migrants was automatically vested in the custodian of enemy property for India under notification number such and issued in exercise of powers conferred by Sub-Rule 1 and Rule 133V of the Defense of India Rule 1962. The following enemy properties situated in Mauja such and such, owned by Sayyid Iskandar Ali Mirza, declared as enemy property. Then they have given a list, my lord. Department never claimed that Sayyid Fateh Ali Mirza was an enemy. Never claimed that Sayyid Fateh Ali Mirza was an enemy. Department had not vested the property of Sayyid Fateh Ali Mirza at any point of time. RS record, Lordship kindly take note of this. Department never claimed that Sayyid Fateh Ali Mirza was an enemy. Therefore, from whom we have acquired our interest. Department had not vested the property of Sayyid Fateh Ali Mirza at any point of time. RS record of rights in the name of Sayyid Iskandar Ali Mirza, son of Sayyid Fateh Ali Mirza, and after vesting, these enemy properties were recorded in the name of custodian of enemy property for India in the LR record of rights. LR record of rights have already been filed with the written statement. In 1969, report by JLR of Murshidabad directly clearly shows that the government had taken possession of the property on 1968. At that time, it was given to lessors on lease. Then two, disputed possession based on RSF record. It appears from the exception that petitioner might have in such preparation which showed that the office of the custodian of enemy property has prepared the RSF record of rights. In this context, it is pertinent to mention that office of the custodian of enemy property did not prepare the RS record of rights. RS record of rights was made by the Department of Revenue officials of the respective state government, and it was prepared based on the conclusive proof of death, as the properties were devolved by virtue of inheritance. My lord, kindly skip it for him. According to them, it is devolved on inheritance. Mat khosra were prepared depending upon the actual possession of land, but the alleged CS Khotian, which belonged to Sayyid Fateh Ali Mirza, my original owner, my lord, Sayyid Fateh Ali Mirza, was distributed by the authority concerned of Revenue Department after the death of Sayyid Fateh Ali Mirza to the legal heirs of the deceased Sayyid Fateh Ali Mirza, as he died in the year 1948. Based on the predecessor interest, Sayyid Fateh Ali Mirza became the owner of the said enemy properties, and his name was recorded by the authority concerned of the state government revenue department in his record of rights. Question of possession does not arise at all. Have you, my lord, seen it? Interfinding. It is further submitted that Sayyid Fateh Ali Mirza, the alleged executor of the Hibanama dated 10/12/1950, died in the year 1948, which was much prior to the date of execution of the alleged Hibanama. The date of death was duly certified by Sri Jayanto Mondol, WBCS Executive Manager, Murshidabad State Judicial Department, Government of West Bengal. Report submitted by the State Manager. A genealogy of Sayyid Fateh Ali Mirza was also annexed thereto within the said report. Based on such information, it is clear that Sayyid Fateh Ali Mirza was not alive during the execution of the alleged Hibanama. As such, genuinity of the Hibanama is questionable, or you kindly mark it questionable. It appears that The alleged Hibanama is nothing but a false, fabricated document and void ab initio having no legal implication. While answering the date of death of the act by the Honorable Forum, these petitioners were failed to produce any cogent evidence. They, though they are through their learned, only mentioned that through local inquiry, they have learned that the probably Fateh Ali Mirza expired in 1959 and 60, which is nothing but a concocted and fabricated statement without having any legal base authenticity. Where the date of death is questionable, there was no scope of probability and presumption. Only documentary evidence can remove the difficulties. In this context, the submitted report of the state manager being a statutory authority as annexed above is sufficient enough to prove the issue of dispute of the death of Sayyid Fateh Ali Mirza. Onus of proving the genuinity of the Hibanama deed is no way whatsoever be shifted to the responding authority. Burden of proof to prove always lies with the petitioner, and the petitioner have or failed to prove the same. Not only the genealogy, the relationship as mentioned in the alleged Hibanama was totally wrong as compared to the genealogy provided by the statutory body state manager of the Murshidabad District Judicial Department, Government of West Bengal. There were numerous instances where registered documents have been forged, as unlike recent days, there was no such scope available with the registering authority for those strict biometric, etc. verification of any person, seller, buyer, donor, donees. Mere production of registered deed does not prove the genuinity of those deeds. When the authenticity of deeds and its existence are challenged, it is the duty of the petitioner to prove the same before the Honorable Forum by evidence. Onus of proving the same cannot be shifted to the respondent. Fact-finding order of Section 5. Subject properties were vested under the Defence of India Act 1962 by virtue of notification dated 10/9/1965. When the enemy property 1968 had come into force. Hence, the question of fact-finding order under Section 5 does not arise for this present case. Section 5 fact-finding order as alleged by the petitioner lies with those under process cases which are vested after enactment of Enemy Property Act 1968. Proof of death of Sayyid Fateh Ali Mirza. Sayyid Fateh Ali Mirza died in the year 1948. Source, Worship kindly, report issued by the statutory authority, that is State Manager of Murshidabad, Judicial Department, report issued and signed by such a statutory authority itself. Conclusive documentary evidence. 2. Substantiate the date of which is based on a book. Lordship, kindly mark it, which is based on a book written by the grandson of Sayyid Fateh Ali Mirza and son of Iskandar Ali Mirza and the said Humayun Mirza himself, an acclaimed scholar, author, retired from World Bank after 30 years of service. However, death certificate could not be traced by district authority now. Nor has the death certificate of Sayyid Fateh Ali Mirza provided by the petitioner. The registered deed is sufficient proof. There were numerous instances where registered documents have been forged, as unlike recent days, there was no such scope available with the registering authority for thorough and strict biometric, etc. verification of any person, seller, buyer, donor, donee, etc. Mere production of a few registered deeds does not prove the genuineness of the document. When the authenticity of deeds and its existence are challenged, it is the duty of the petitioner to prove the same before the Honorable Forum by evidence. Onus in no way whenever be shifted to the respondent to prove the case of the petitioner. Sayyid Fateh Ali Mirza died much prior to the date of execution of the alleged parent deed, Hibanama. Alleged Hibanama is itself void and void ab initio, and accordingly all subsequent transactions were also void. Petitioner had not acquired any right, title, interest and possession from the said disputed chain title. Genealogy of Sayyid Fateh Ali Mirza, genealogy and relationship as mentioned in the alleged Hibanama was totally wrong as compared to the genealogy provided by the statutory body. State Manager of the Murshidabad District Judicial Department. Said report was derived from a book written by the grandson of Sayyid Fateh Ali Mirza, son of Mirza, and the said Humayun Mirza, who himself is an acclaimed, then a repetition of the same. I'm skipping over, Miller. Even now, the documents produced by the applicants have been examined. That's the fact finding, Lord, from sixth finding. The documents produced by the applicants have been examined, and the submission made by the respective parties have also been considered in depth in the light of the governing provision of EP Act 1968 as amended by the Enemy Property Amendment and Validation Act 2017. From the foregoing facts, it is evident that Sri Fateh Ali Mirza, the alleged executor of the Hibanama dated 10/12/1952, died in the year 1948, which was certified by Jayanto Mondol, WBCS Executive Estate Manager, Murshidabad State Judicial Department, Government of West Bengal. This makes clear that the date of Sayyid Fateh Ali Mirza much prior to the date of execution of the alleged Hibanama. The applicants have not produced any other acceptable evidence which creates doubt or dispute the date of death of Sri Sayyid Fateh Ali Mirza in 1948. As regards the contents of a specific vesting order of the Enemy Property Act after 10/9/65, an identical contention was raised and relied by the Honorable Division Bench of the Honorable Court Judicial Sajjad Tawfiq Ahmed Adar, wherein the Honorable Court expressed that the effect of notification is not confined to the properties which were owned, held by, managed on behalf of Pakistan nationals, and the date of notification would equally apply to the properties which came to the owned, held and managed on behalf of Pakistani nationals at any time till notification remained in force was at all necessary to issue fresh order under Rule 37 individual property which came to be owned by the Pakistani after September 10, 1961. The applicants relied upon the judgment reported in AIR 2001 Supreme Court in the written submission dated is not attracted in the given facts and circumstances of the case as Sri Fateh Ali died in 1948, which was duly certified by the Jayanto Sachansar judicial member after careful consideration of the entire facts and circumstances case available in the record. Herein after the property in question has rightly vested to the vested quarter, their claim of the applicants could not be. Therefore, my lord, the entire finding in substance on the issue, a judicial officer, estate manager holding the post.
Estate manager is not a judicial officer.
Executive officer, whatever.
Executive officer.
Executive officer has certified he died in 1948. Then I should show what is the certificate about. In giving this certificate, he relied on which document? Lordship kindly sees.
So far as the act is concerned, that is the Enemy Properties Act 1968 is concerned, where is any bar to entertain any such question by a civil court?
That they have quoted. That they have quoted.
May I show the relevant provision? May I see the relevant provision?
Just a minute.
In the order under challenge, yes, sir. In the order under challenge, if I have correctly understood, if I am not, please let me know. But let me understand rather that the the authority has placed reliance much upon the report of the Jayanto Mondol, the estate manager of such and such, regarding the certificate issued by him regarding the date of death of Fateh Ali Mirza. And his report is based on a book. And secondly, the authority has come to a finding that the Hibanama, as has been executed on 10/12/1952, is not a genuine one.
Because a dead person
A person cannot execute such a manner.
Yes, yes.
Whether under that act, the authority can come to that finding or not. It's like a civil court.
Yes.
That is to be
That
questioned.
is, and another question, my lord, I should show your lordship the certificate of the estate manager, what he said about it. My lordship kindly sees it. Based on a certificate of
No,
estate.
let me say, please show me the relevant provisions of the act, whether what are the restrictions of the upon a court that have decided, that have been quoted in the order under challenge.
Section 22A. Yes, my lord. Have your lordship got the act?
No, I don't have. Kindly give it. Section
22A, capital A. ওটা রুল আমার কাছে বই আছে। আছে দেখ না, নোটিফিকেশন আছে, ওই আছে, বই আছে না। ওগুলো আছে, একটা আছে দেখ, পেজের নোটিফিকেশন আছে আমার, দেখ এর মধ্যে আছে, দেখ। গেজেট আছে একটা, দেখ। আরো আছে দেখ, তাড়াতাড়ি তুলে দিস না, আরো এটা তো শেষ নেই কিন্তু না। 21
There is a provision of the appeal in the High Court.
Well, that is the
that also
that is
that
the issue I
also
wanted to take.
yes
There are
There is a
judgment-
provision of the appeal.
yes
Any person aggrieved by an order of the central government under section 18 of this act may, within a period of 60 days from the date of communication or receipt of the order, file an appeal to the High Court on any question of fact or law arising out of such orders, and upon such appeal, the High Court may, after hearing the parties, pass such orders thereupon as it thinks proper, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing an appeal within the said period, allow it is to be filed within a further period not exceeding 60 days.
There is already a judgment of a division bench of Delhi High Court which has held so, my lord, that in appeal, first appeal has to be preferred.
So alternative remedy is there, sir.
I would submit, my lord. I am ready with the answer. I will also submit. Let
Yes.
me complete it.
Allahabad High Court.
No, I will.
Let me complete it.
Yes.
No, my lord,
Then
if
that
this
certainly-
point there, he may.
No, wait. You will get
I'll
a chance.
I'll give him the judgment also.
Yes.
Then, as I have shown the entire, my lord, they have relied upon a certificate of a state manager for the purpose of coming to the conclusion that this person died in 1948. As such, there cannot be a question of any execution of document on his part in 1952. On that score, it has been rejected. Then in that image, my lord,
So then, for the sake of argument, Mr. Rai, if I accept your contention that the appropriate authority cannot act as an civil court, he cannot declare the deeds, including the deed of Hevanama, as null and void. For the sake of argument, if I accept your contention that the appropriate or that the authority which passed the order under challenge has wrongly come to a finding to the effect that such and such person died on such and such only on the basis of a report of a estate manager, which has got no value in the eye of law. For the sake of argument, then you have to cross the hurdle of section 22A, clause C, that no suit or other proceedings shall, without prejudice to the generality of the foregoing provisions, be maintained or continued in any court or tribunal or authority for the enforcement of any decree or order or direction given by such court or tribunal or authority directing divestment of enemy property from the custodian vested in him under section 5 as would suit such and such.
Therefore, civil court is barred. Peculiar. Civil court is barred.
Not only civil court, all court. No suit and other proceedings shall pay for direction for divesting 22A clause C is a bar.
Therefore, my lord, parties are stopped from raising any question or any manner. Does it say so?
No, this, which is why a provision is there under.
But if there can't be any questions.
But a provision is there under Article 80C.
Therefore, there cannot be any question, no question can be raised, irrespective of any decision finding of the enemy property act. If that be the proposition, my lord, High Court should not have entertained it. Whatever done pursuant to court's direction, it is not a simplicity that I had been there. They are accepting objection under section 18, statutory. There is a power of testing it. Anybody can, irrespective of, can raise a question of vesting, that is section 18. That they are accepting this power, giving the parties to approach under section 18. One thing, Lordship, then as the law, this honestly, my lord, I have not exactly in contention go through this part. I have to study it. Even then, my lord, I am before the authority pursuant to court's direction. Honorable High Court exercised this power under Article 226. And Honorable High Court directed them to deal with my representation. They have dealt with in a manner.
Rightly or wrongly, they have dealt with a manner.
What would be my forum? I have had been there pursuant to court's direction on affidavit.
No, has section 22A clause C has been declared ultra vires?
That is not known to me. That is not known to me.
No suit or other proceedings shall, without prejudice to the generality of the foregoing provision, be maintained or continued in any court.
But facts remain in place, Honorable Court entertained it. Honorable Court dealt with the issue.
No, entertained only for a limited purpose, for the purpose of consideration of a representation.
No, there has certain fact finding was there. I have showed.
Those are tentative findings.
Even assuming fact finding.
Ultimately,
Honorable Court directed the authority to deal with him.
Subordinate bench may make some tentative finding.
Yes.
Try to understand.
Yes.
It is a purely law point, not a factual point. Don't go by emotion.
No.
Go by the logic.
I follow
go by the logic and go by the what I'll say, by the concept of law.
Yes.
And I'm here. I'm rather eager to hear you.
Yes.
Sir, what I'm on, sir, rightly or wrongly, the authority which passed a reasoned order may be an unreasoned order. If I, for the sake of argument, I once again repeat, for the sake of repetition, even in everything, that the authority has no power to declare a particular deed as a null and void, which authority has, a civil court has, under the Specific Relief Act only, by trial on evidence. For the sake of argument, even if I accept that the estate manager of Murshidabad estate, being an administrative officer, has no power to issue a certificate of death, that too on the basis of a information available from a book, maybe published from USA or from any other state. Sir, what I'm on, sir, whether those findings can be challenged in a proceeding under Article 226 of the Constitution of India in clear bar of section 22A(c) of the Any Property Act 1968. That is my question.
I followed you, Lordship.
That is my question. Especially when this made it more difficult because there is a provision under the 18th Act for providing appeal.
So then 2 is destructive.
I'm one thing. You make an endeavor.
I follow. As much as fallen for Marshal.
No.
Yes.
Listen to me. Please make an endeavor for this day, even in the night, to keep your candle alight till the midnight and come back tomorrow at 2 p.m. I'm ready to hear. If you continue, I am ready to hear.
Not tomorrow, my lord. Give me 2 days.
Very good.
Give me some time. I have to satisfy. I have to satisfy your lordship. Give me some time to go through it. Another thing, my lord.
Get yourself satisfied first, then satisfy the court.
Only one thing, my lord. before Lordship, and only one thing.
Because
just
very
to-
crucial question of law I am
Yes,
raising.
I follow, my lord. I follow.
Mr. De, am I correct on this point?
My lord, only one thing, my lord. My lord, only one thing. Before Lordship, I have borrowed your Lordship. I will try to satisfy your Lordship in a.
But be assured, Mr. Roy, I have not framed on mind.
No.
I have only
Only
raised
one
some
thing. Before
crucial
that,
question of law.
3 pages, Lordship, kindly see. Factually.
Yes, sir. Yes, sir. Yes, sir.
Page 154. না না এই তো সব তো যা আমি একটু বাইরে রিড থেকে রে বাবা রিড ফিট
I could have heard out the matter. I could have passed a judgment.
Yes.
But I think some academic
discussion is needed.
No, some academic preparation is required.
Yes.
Both from the side of the members of the fraternity as well as from the bench.
Yes, Lordship, kindly turn page 154.
154. টা কোথায় বাবা?
Of the read petition, my lord.
Yes, yes, I got it. Report of the estate manager.
Yes, I am not going over it. 4th paragraph. Say underlined. Sayyid Fateh Ali Mirza died in the year 1948.
You are referring which portion, sir? Yes, yes.
Underlined.
I got it.
Sayyid Fateh Ali Mirza died in 1948. Date of his demise is not available. Source, reference, page 344. Book name From Policy to Pakistan, such and such. American edition, published in 1999 by University Press. Yes.
Only surviving son
Yes.
of
Iskandar Mirza. This is a certificate. He is giving a reference. Lordship, kindly turn to next page. It is not his independent finding, not on any fact finding. She is solely relying upon this particular page. What I say, my lord, from I am reading. It is very Sayyid Fateh Ali Mirza, born 1926, died in 1948. A very bracketed portion, my lord, from the top left hand side. Therefore, my lord, sin source is this particular page.
Sir, I understand.
And second page.
I understand, sir.
A person died, date, month, year. 3 things is essential. Here is he died in 1948. No mentioning of any month, no mentioning of any date, of nothing. Source is book. And this particular reference has been taken as sacrosanct. It is not a case that even assuming a state manager has the authority to give a certificate of death of any person, his solely reference is being made on this basis of this particular page, undisputed fact, my lord. Where my lord will not get a semblance of any month, date of year of a person's death, which is essential.
Sir, kindly work out on section 22A. It says notwithstanding anything contained in any judgment, degree, or order of any court, tribunal, or authority, no suit or other proceedings shall, without prejudice to the generality of the foregoing provisions, be maintained or continued in any court or tribunal or authority for the enforcement of any degree or order or direction given by such court or tribunal or authority directing divestment of enemy property from the custodian vested in him. So for sir, I'm just for academic reason I'm telling you, sir, for the sake of argument, even if I accept your contention that the origin order has been passed by virtue of a order passed in a 226 proceeding by a coordinate bench of this court, and for the sake of argument, even if I accept that the logic as given in the origin order by the authority is not acceptable, and to that extent, if I allow your writ petition, it has an effect of divestment of the custodian property, which is barred under prima facie barred under section 22A clause C of the Act of 1968.
Yes.
This is the difficulty.
And another thing, my lord, so for divesting parties, I will be submitting with.
Let me see what is your prayer. Set aside the order, was the decision of divesting. That means divesting. So 22A clause C is the bar.
No, I'd be showing to your lordship based on judgment of the Honorable Supreme Court.
Come ready. Come ready.
It does not vest to the enemy
Your
property.
lordship, I have just realized that if this order is even set aside.
Which order has been set aside?
This order. The land does not go back to him. There has to be a which he has not prayed. Section 18 is an application for transferring back of the land. Vesting has already gone. Vesting has been done.
There is no vesting. As I showed to your lordship,
He has not even given the prayer.
there is no vesting.
Are,
They let them show by act implication of act this has been vested.
then section 18 does not lie if there is no vesting. Then let him go and file a suit. Section 18 to provision ही आला था. Section 18 तुमको vesting मानते हो?
No, section 18, my lord has gone it. Section 18.
In such manner as may be
Kindly
prescribed.
please, sir.
Section 18. The central government may, by general or special order, direct that any enemy
No,
property.
that has been amended. That has been amended.
18 is not amended.
Yes, sir. It stood amended by the section 18. The central government, it was previously. The central government may by on. It is
Section 2016 amendment আছে?
It is 18 has been amended. Central government may, on receipt of a representation from a person, aggrieved by an order
By an order of vesting.
as enemy property in the custodian within a period of 30 days from the date of receipt of such order or from the date of publication in the official gazette, whichever is earlier, and after giving an reasonable opportunity of being heard, if it is of the opinion that any enemy property vested in the custodian under this act and remaining with him was not an enemy property, it may by general or special order direct the custodian that such property vested as enemy property in the custodian may be transferred to the person from whose such property was acquired and vested in the custodian. So the power is with the central government.
Power is with the central government. He not only has to seek an order of setting aside, he also has to seek an
department.
He also has to seek a prayer that the matter.
That order is appealable under section 18C.
Yes. It is a sequence, my lord.
Sure. Tell me which date will be convenient.
Next week, any day.
Next week?
Yes, yes.
Sir, why so late?
No, some.
Vacation आगे खटा में.
No.
I'll not release this.
I will not take. No. Next week, any day.
No, sir. No, sir. Today is on 5th May. No, you come on either 7th or 8th. 8th. 8th you have to come.
9th is holiday.
Yes, very good.
Monday can it be? If possible, subject. I will not bargain, Milord.
Monday is a holiday, sir.
Monday 19
Monday
sir.
or Monday.
9 तारीख
Huh?
Next week, if possible, my lords. I'm not bargaining, my lord. Sorry, because some pressure is there with me. That's I follow. My lord is limiting my. Yes. Yes, that's true, my lord. If possible, my lord, I will not bargain. Subject to my lord, I know my lord's prediction. I have some problem with this week. 13. Yes, at the top, my lord. I will, whatever maybe, I will admit.
हमारा तो देखता है
Do
खाली
the
मीटिंग का
poll
देखो खाली
I have indicated the right point of law. Let him explain.
Especially buttressed by section 18C मतलब.
Let me see. Yes.
Malad, before taking up any other matter, Malad, regarding item number 153, Malad, 153 is tagged with item number 152. There are so many matters from item number 152 to 156.
Madrasa.
But this 153 is different, Malad. This has already been disposed of, Malad. And this is not at all a madrasa matter.
Very good. It will be corrected.
This matter already disposed of on 5th of October 2020.
I understand. It will be corrected. Which has been disposed of?
Item number 153.
53 has been disposed of?
Yes, my lord. And it is not a madrasa matter, my lord. This is altogether a different matter.
Wrongly listed.
I'm grateful.
Item number 163.
Not today, Kodak.
164.
Not today, Kodak.
Number 165.
Next. Not today.
Number 167.
Not today.
Lordship, 164.
Not today.
Uh,
You are for?
I am for the petitioner, Lordship.
Who is the other side?
Learned Advocate Mr. Shiv Chandra Prasad. I want to file my reply, Lordship, today.
So
Transfer
why not responding at the time of call?
Lordship, on the last occasion, opposition was filed by Mr. Prasad.
I will serve copy.
Yes, Lordship.
You have served copy to the Mr. Prasad.
Yes, Lordship.
লিখুন
My reply, Lordship.
ওটা কত নম্বর ছিল? ওটা কত নম্বর ছিল যেটা অর্ডার দিলাম?
4, Lordship.
164.
Yes.
Yes. যেগুলো যেগুলো আসবে না সেগুলো নিয়ে আসবে তো আমার কাছে। এই রকম এরকম লুজ রেখে দেবো তো খুব রিস্কি। হ্যাঁ, তুমি একটা ফাইল করো, ফাইল কভার করে রাখো।
এখনো একবার পাঠিয়েছি আর
নোট টুডে করো।
Lord, I am for the petition number.
Your application.
Application for restoration, my lord. In fact,
ফাইলটা দিন।
Mr. Chonji Charan De.
হ্যাঁ আমি আছি। তুমি এটা আছো নাকি?
হ্যাঁ।
What is can 1, can 1, what is can 2, what are can 1, can 2 and can 3 for?
Can 2 is restoration, can 3 is section 5.
And can 1?
I am not pressing, my lord.
Not pressing?
No.
Very good. Can গুলো দেয়া আছে এখানে?
Restoration.
অর্ডারটা কোথায়?
এটা
অর্ডার গুলো কোথায়? ও আচ্ছা আচ্ছা আচ্ছা, এখানে রয়েছে। 2005-15?
Entirely, my lord. I made an application for expeditious disposal, my lord. Now the person is a cancerous patient. I am fully blamed. I am responsible, my lord, for it. Kindly restore it. Here I will have fresh notice, fix a date.
Can 3 is the restoration application?
Can 3
or is the condonation of delay?
Yes.
How much delay?
Delay is.
My goodness. Which paragraphs are relevant?
My lord.
Show me the relevant paragraphs. 164.
Paragraph 13, my lord. Yes, আপনি আছেন। Lord, 10 to 13.
Mr. De, 2,869 days delay.
I never oppose restoration of. I never oppose.
আসুন, can 3 of 2 तो ये पीछे है ना. So I am looking forward. Why should I go back? Call the next matter. Yeah.
Well, restoration application, I do not have any objection.
170.
171.
অসুবিধা
But Mala, there is a matter of propriety involved, Mala.
Dismissed on 26th February. I have filed on 10th March. Filed within
Very
time.
good.
Well, the order was
What are
passed.
the cans?
Mala, no, only one. Only one.
Can two tower কোথা থেকে এলো?
Can 2 has already been disposed.
Disposed,
Can 1
one.
has already been disposed.
Have you annexed the order, sir?
Yes, yes.
Yes,
That is at page 7.
Within time.
Well, there is one problem.
Key problem? What problem?
Order has been passed by Mala Justice Ananya Bandyopadhyay.
So
she still has the jurisdiction.
But your lordship have also the jurisdiction.
I have determination.
Well, it's propriety. That is why it's only
No, no.
propriety.
He otherwise he has to move from pillar to post and post to pillar.
Should have been filed there, my lord.
No. Should have.
In that court.
Asun, can 3 of 2025. What is the subject matter of the incident petition?
This disciplinary proceeding, he
I
was
have challenged
involved.
the charge sheet, my lord,
Charge
on the
sheet
ground
stage,
there is a
early
bill of
stage has
4
been
and
charged,
4 and
not
5,
final order.
4 years, 5 months. And my lord,
Earlier stage charge sheet
they
has been
allowed their
challenged,
IPS
stay-
officers to
stay
go
was
thereafter issue the
refused,
discipline charge
stay
sheet
was
against the
No, sir, tell me one thing. In the event that they proceed with the disciplinary proceeding,
lordship.
and in the event the court finds that the charge sheet goes, your entire proceeding will be quashed.
But
So
they
how we are
cannot,
going to be prejudiced?
but they cannot
They will
now
start and they will ask the petitioner to appear. The
Hmm.
disciplinary proceeding has
Appear.
been stayed. On the ground, my lord, both are running on the same set of facts, same set of evidence, and same set of witnesses. And
No,
my
no,
Then
sir,
my
what
lord,
is your prayer in the repetition?
there
Let
are
me
two
see.
prayers in the
washing of
repetition.
the
An initial my lord, interim
Give
order
me a
was
second.
granted
Give
by
me
the
a second.
division bench.
Commanding for to the memorandum of charge. Yes. If the charge sheet goes, the entire proceeding will go.
Disciplinary proceedings, there are two prayers.
Let them
Kindly see the
participate.
prayer B.
Huh.
Cancellation as well as I have prayed for my stay of the disciplinary proceedings. As both are running on the basis of same set of facts.
No, no, sir.
They have started, my lord. They have already started it.
I
Take one
understand your contention, but try to understand what I'm saying. By filing the instant need petition, you have challenged the memorandum of charge sheet. Am I correct? On the basis of the memorandum of charge sheet, they are proceeding with the matter. Am I correct? For the sake of argument, they have come to a finding that the delinquent is guilty of the charges. And in the event the charges sheet goes, that will automatically go.
There is two prayers I have in this writ petition. First, my lord, quashing of the charge sheet. Second, stay of the disciplinary proceedings, as disciplinary proceeding and criminal proceeding are running on the same set of facts, same set of evidence, same
Criminal
set of
proceeding?
witnesses. Yes, a criminal proceeding is pending against the petitioner.
Identical evidence are introduced.
Same, everything is same.
Very good.
I
Let
can
them
satisfy your lordship that everything is same.
Uh,
If they do not
my
have
lord.
any original
Acha,
document.
My lord, but
it
they
is,
do not.
at this stage, এটা আগেরটা কোনটা ছিল? এটা আগেরটা 171 ছিল?
Lordship, in this matter, I am appealing on the state, Lordship.
Is not in the application. There is defective, my lord. I have to withdraw this application for substitution. Kindly give me leave.
দাও আসুন
Section 5.
174.
restoration নেই, not today করে রাখুন।
Item number 175, 176.
not today। দেখি একবার ফাইলটা, 2010 সালের মামলা। The parties are not represented today. Stop. Let the matter be listed on May 13, 2025 under the heading for dismissal. Next.
Number 177.
177, my lord, I am appearing for the petitioner.
My lord, keep it next week, my lord. I have ready with the affidavit as your lordship directed.
Let the
file be placed.
There is a direction, my lord. There is an affidavit filed in this matter. We have also given a reply. My lord, the affidavit is not probably available with the records. The
Earlier learned advocate was affirmed the affidavit and he had died. As such, the affidavit has not been filed.
It will be in opposition.
Opposition. Learned court earlier occasion giving me liberty to reaffirm the same. I have reaffirmed the same, my lord. Kindly keep it next week. I can
file it.
It is my fault, my lord. I could not serve. All are ready, but I could not serve.
It was not reaffirmed.
Affirm has not served to other side. A similar affidavit.
So serve a copy in the meantime.
Yes, my lord. Kindly keep it next week.
Not file it today.
No. Annexure should be Xerox, my lord.
So it is not ready. Actually. Asun.
One 178, I am the state respondent, my lord.
Not today.
Well, 179, my lord, there was an order of demolition. I am appealing for the cantonment, but we have already demolished. So
not today.
Well, let it come up. Let it be given some priority. It has writ petition has become infructuous. As per the order, we have demolished the because petitioner had filed an application. Possibly there is a report also. Brief আছে রিপোর্টটা ফাইল হয়ে গেছে না The report has also been submitted, my lord.
Yes. একটা কাজ করুন তাহলে the writ petitioners ওই ফাইলটা না একটু আমার কাছে পাঠাবে।